Well, welcome back, everybody, on this fine election day. I know many of you are going to want to be running off to watch the returns. It is a busy day in the United States today. But it was also, of course, day 19 in the trial of State versus Richard Allen here in Delphi, Indiana. And so I want to just go ahead and get right to the big picture for those of you that are going to want to be paying attention to other things this evening. I totally get it. You may not want the full multi-hour breakdown. So let's just go ahead and start with the big picture. We heard today from Betsy Blair, who established that the car at the CPS lot was not Rick's. We heard from Dr. Stuart Grassian, an expert in solitary confinement. We learned from him that Rick was tortured and that his confessions are probably false. We heard from Dr. Eric Warren, a forensic firearms examiner. From him, we learned that you cannot compare fired to unfired rounds, and the results of the state's examiner don't stand up to objective standards. And lastly, we heard from Stacy Eldridge, a cell phone forensic examiner, who informed us that data on Libby's phone showed that somebody plugged a wired headphone or an aux cable into her phone at 5:45 p.m. and unplugged it again at 10:32 p.m. on February the 13th. Only other really critical information that we got today is that the state is really, really bad at cross-examining experts. Had a really bad day with this. So let's go ahead and get into the details. I want to start with the issue we've been having with the courtroom seating. I reported last night that the defense appears to be having their seats taken away. And that continued today. Now, the courtroom decorum order, allocated 10 courtroom seats to the defense and to Richard Allen's family. That has apparently dwindled down to now about 6. And this is becoming a problem because they can't fit everybody that is on the defense team and the family supporters all in the places where they're being allocated. What's happened is that previously the 2 front rows of the courtroom were basically being allocated to the press, to the media. And one of the full rows on the right-hand side of the courtroom was being allocated to Rick's family and to the defense. Apparently, it appears the prosecuting attorney has taken over the front row on the opposite side of the courtroom. And so the media members who can't now occupy that row, they are spilling over into the defense row. So this became an issue today because present we had Rick's father, his stepfather, Rick's mother, his sister, Jamie, his wife, Kathy, Kathy's friend, Bob Mata, who's been sitting in the defense row pretty much since day one. And then they had 2 defense investigators who also needed places to sit. There was a third person as well, who I'm not sure exactly who this person was, but this person was originally seated in the defense row. So the defense had 9 people there, well within their allocation, and yet nobody's making the media give up their seats for the family. So this was kind of not cool, I thought. Really kind of not cool. Like, these are straight up members of the defense team. One of them had to sit out in the hall. I don't know what's up with that. Order hasn't been modified. I don't think that's very cool at all. As far as who is getting priority in the courtroom, the folks that are involved in the defense, yeah, they should get priority over the press. Real bottom line there. I'll give you the Rosie style watch, the Brad Rosie style watch. He had a lovely, like very soft looking fabric on his gray suit today. It looked like almost like a felt, it's not, but it just has that warm kind of soft kind of quality to it. A very light blue shirt that had, it's a color I would tend to call robin's egg blue, very light, just a hint of it, not an overwhelming color, but you might put it in like a teal or a turquoise kind of category. And he wore it with a very bright violet tie. This tie was like on the warm tone of a purple, very bright. And I noticed when I saw it up close that I think part of the warm tone that was contributing to it is it had this tiny little pinpoint orange dot pattern on it. I will say this was the first tie that I didn't necessarily love it. The color was very vivid. This is probably the most vivid of the ties that I've seen Mr. Rosie wear. I didn't hate it, but I didn't love it. It's just a little look at me, it's a look at me tie, no question about it. Obviously, if that's what you're going for, then this was all it. But Mr. Rosie was largely in the background today. So I don't know, maybe he just needed the tie to establish his courtroom presence for him. We started off today addressing a state motion, which was the state's motion to exclude the testimony from Dr. Grassian or limit it with a limiting instruction. Now, I remember just a few days ago when the defense filed a motion on short notice seeking permission to have their FBI agent testify remotely. And I remember seeing, I think I mentioned it on my stream, during one of the breaks, there was a conversation up at the bench that was not on the record, but it was occurring there in front of the bench between Ms. Auger and Judge Gohl. And I didn't know what they were talking about, but then I hear Judge Gohl kind of, "You just filed it. I haven't even had a chance to see it yet." Appears that Ms. Auger is trying to follow up on this motion, which was the most recently filed motion for the defense, presumably because they would like to know what the status is of their witnesses so that they can make the arrangements accordingly. And so in that situation, last minute motion is just met with this. I haven't even seen it yet. Well, this morning when a last minute motion is filed for the judge, she very kindly points out that somebody printed it off for me and sits up there at the bench and takes the time to go ahead and read through the whole thing. Very accommodating. The state essentially argued that they were requesting a limiting instruction to the jury that would basically tell them that they could not take the witness's testimony as an opinion on guilt, on veracity, on the truthfulness of his confession. Mr. Rosie responded that this motion had just landed on his desk this morning. He's not happy about the timing of it because this witness has been on the list for months and months. They know that he cannot testify about a conclusion of law, but you need to kind of wait until you see what the testimony is going to be before you go and try to get out ahead of it. He argued that when you don't know what the evidence even is, it's really not appropriate to put limits on it ahead of time. There's been no specific statements that the state has challenged, and this is basically because even though they know that this witness has been on the list for months and months, they apparently didn't bother to depose him. So his basic point is that, yes, there is a rule that one witness can't testify about another witness's truthfulness or veracity, even though that didn't seem to be a problem for all those prison guards who testified, he was faking mental illness. That's not the same thing as a witness being prohibited from disagreeing with another witness. They're allowed to disagree with other witnesses, and they can do that if they can do that without offering an opinion on the other witness's truthfulness, saying they're lying, then Otherwise, you wouldn't really be able to have expert testimony, right? If they disagree, and you assume the second one is a comment on the veracity of the first one, you wouldn't be able to have experts. It'd be whoever got the expert up first wins the battle. So Ms. Diener is arguing this motion. She argues that this rule, it's out there, it's well established. Yesterday, there had been a response about some principle about truthfulness, and took it as it was applied to Richard Allen's statement. This must be referring to Dr. Walcott. Doesn't sound like anything that I recall the state objecting to at the time. So they're pointing to like an objection that they didn't make. And so she just says, we just like to make sure that Dr. Grassian knows what the parameters are, and that he should at the least be admonished that he can't testify about truthfulness, intent, guilt of the witness, and no conclusions of law, etc. The judge says, I trust the witness has been told he can't testify contrary to the evidence rule. Evidence rule is 704B, for those of you interested in that type of thing. And as long as he's been told that, then we shouldn't have to worry about putting the genie back in the bottle. And Mr. Rosie has at this point confirmed, yes, he's aware of what the limitations of the testimony are, what lines he's not allowed to cross under the evidence rules. And Ms. Diener said, well, there's been no report. So short of a deposition, there's no way to find out what his statements are. And yes, short of a deposition, that's your option. So the judge says, well, naturally, the defense doesn't have to provide a report. It's not in the rules that an expert always has to prepare a report that can be provided over to the state. And in fact, as we'll see, it's very commonplace to not do that. And so it's up to you to follow up if you don't get a report and have what you want. And she says, as long as he knows that the limits on his testimony, as long as he knows what they are, fine. If he steps over the line, then we'll be having a harsher conversation out of the presence of the jury. We'll excuse the jury and have a harsher conversation. So Mr. Rosie indicates that as a courtesy, he will step out and he will remind Dr. Grassian of the rule and the limitations of the rule. I noticed through the course of this conversation, the state is basically saying we don't really have a problem with taking expert testimony about these general principles that he's going to testify to. The real problem that they had, and that they were pointing to yesterday as being an issue, is when you go and make specific conclusions about this case from that testimony. And I found this quite remarkable, since the standard for relevance so far has been so narrow that basically it has to be exclusively about Rick Allen and exclusively about specific dates in question. It's you can't go outside of those guidelines, or she's sustaining relevance objections when it comes to the defense. And yet now suddenly we are 180 degrees in the other direction. We can't actually testify about Rick Allen. We can only testify about the generalities. This is just wild how anybody is supposed to ever keep track of what the rules are in this courtroom, because they are changing every day. Mr. Rosie took care of that while Mr. Baldwin called Betsy Blair to the stand. We have, of course, seen Betsy Blair before. She was a state's witness, but when the defense attempted to question her about the car she had seen parked in the CPS lot when she left at about 2:45 that afternoon, that was objected to as beyond the scope. So the defense has had to recall her. I can't imagine that is pleasing to her. It's bad enough people have to take time out of their day when they get subpoenaed to go to court once, but then the judge doesn't care about your convenience and makes you come back and do it a second time. Mr. Baldwin started by asking, how many questions did the state ask you about the car you saw parked at the CPS lot? They really want to make this point. There is certain information that the state hasn't wanted to investigate, hasn't wanted to elicit, hasn't wanted to bring out and inform the jury of. So he started right off the bat with that point. The answer, of course, is none. They asked no questions about that. So she recapped very briefly her day on the trails on February the 13th of 2017. She went to the trail twice. She left for about half an hour in between. Then she came back. The second time she got to the trail, it was about 1:45, and then she left about a quarter to 3. No, I'm sorry, quarter after 2, about quarter after 2. So she turned left on 300 North as she came out of the lot. We know previously that she parked at the Mears lot. So that is what took her past the Hoosier Harvest Store video camera. She described the area as having a business on the north side, a house on the left side, and then an empty government building near the trail parking lot. And after that is the entrance to Anderson's Grain. And other people have called it the CPS lot. She herself does not call it that, but recognize that other people also called it that. She saw one vehicle in the lot when she went by, and she noticed it because it was not parked how people typically park when they use that area to go to the trails to walk. She described it as being way up back by the building. It was turned so the front was facing the road, meaning that it was kind of backed in. She remembered the overall shape of the car because it looked like it had very sharp angles. It was a sedan, and it reminded her of a car her father had, a 1965 Comet. She did not really remember the color of the car at this time. She remembered that it wasn't bright. She did not initially remember whether or not it could have been a black car, but she was refreshed from a deposition that she took back in April of 2019. So quite some time ago, when you would expect her memory was a lot fresher. And at that time, she said it was an indescript color and that it could not have been black. She did not see the back of the vehicle. She only saw the side of it. And she had drawn a profile of the vehicle that she saw and gave it to law enforcement. So that drawing has been introduced into evidence as Defense Exhibit LLL. And it's just a basic outline of like the profile of the car. That was all from Betsy Blair. Ms. Diener testified that she had cross-examined her that she had also spoken with police on February 17th of 2017. She had gotten copies of all her statements. She had told them at that time that she noticed the car because it was closer to the building, backed in, slightly at an angle, nondescript sedan, and not new. It's not helpful to the state, so I'm not sure why we're reiterating it. But she brings up that there was another witness who saw a vehicle that had been parked, kind of turned off the road, and it could be similar. And she asked if that could change Betsy's recollection. She's wanting Betsy to think perhaps that maybe the car that she remembers was parked somewhere else, or maybe she's remembering a different car, trying to conflate Betsy's recollection with that of the prior witness. And Betsy said, I feel certain it was the shape of the car that I saw, and it was at the CPS lot. So nope, it did not do anything to change her recollection. Asked about how good her vision is, her eyesight, she says that she wears contacts and she had them in all the time. So overall, not particularly successful cross-examination of Betsy Blair. And after that opening, yeah, it's just another instance of kind of making it look like, it's an own goal by the state. It really is. It's an own goal by the state to not bring the stuff up and get out ahead of it and just leave it for the defense to bring up in the context of, wonder why they didn't tell you any of this stuff. This is something that I think that the state is really not used to. The defense has to deal with bad facts all the time. The defense is always dealing with bad facts. Mr. Allen is having to deal with bad facts. Like this is just part of what's normal for people on the defense side. And it doesn't do you any good to ignore them. It really doesn't. If they're bad facts that can't be overcome, then you shouldn't be at trial. Obviously, it's not always your choice, but you're advising your client, we're not going to get past this. Like, I don't know that there's really anything we can do with this. And the jury's going to hear it. So what do you want to do about that? Can't make it go away. If there is, some way that you can handle it, a reasonable explanation for why this fact that appears bad is actually not, all right, then you go ahead and roll with it. So it's something that the defense is very used to doing, but I don't think the state is. I think the state is pretty comfortable, pretty used to having their law enforcement witnesses that everybody is going to believe. Nobody's really going to question them. If there's like a dispute between what the defendant says and what the officer says, then everybody's always going to find the officer more credible. That's the kind of situations that they're used to dealing with. So they've never really had to work to get around bad facts. And it shows. It shows because their strategy has just been to put their head in the sand, and it ends up making them look deceptive. It makes them look like they are deliberately hiding from the jury the stuff that tends to undermine their case. And that's not a good position to be in when your whole point in being in front of the jury is to convince them that they can trust you beyond a reasonable doubt. Not a strong start to the day for the state. We had some jury questions. First question, is it possible the car parked at the CPS lot belonged to someone in the building working? And the answer to that was that the building was abandoned and it had been for some time. And so similar question, do you know if anyone checked to see if it belonged to an employee? She did not know. Don't know that there, would be any employee at that time, at that point in time. Don't recall. I mean, I know the CPS building, that lot has been discussed. I'm not quite sure if it's being abandoned has really been emphasized a lot, or if it's necessarily clear that it was abandoned at the time as opposed to like it was okay then and it's abandoned now. So the jury did seem to misunderstand that, but that's okay because now they have been they've been set straight about that. This is an abandoned building. This was not some employee's car. This was somebody else parking there. And for our purposes, most importantly, for purposes of the timeline that the state has tried to nail down to put Richard Allen out at the trail, his car was not there where they say he parked it. We know, of course, he did not say he parked it there. He actually said he parked it at the other spot, but the state has insisted he said he parked it there. Put it in their probable cause affidavit that he said that he parked it there. Mr. Mullen testified on his direct that Rick Allen said that he parked it there. And we see the interrogation, he said he didn't. This kind of, I think, is going to go back to that defense opening where they said, hold them to their theory. Hold them to their theory, because when the evidence comes out, they're going to have to change it. And so, yeah, now I kind of wonder if there's going to be a shift. Are we going to see a shift now to Rick did not park at the CPS lot? He parked over at the other spot, the second spot that's over on this side. Can't wait to see. Next, we had Dr. Stuart Grassian. Mr. Rosie did handle this particular examination. So I guess he did. He did have a moment today. I had kind of forgotten about that. So Dr. Grassian, he is a psychiatrist. He's from outside of Boston. He went to Harvard for his undergrad. He got a MA in sociology, I believe, from Brandeis. Got his medical degree from NYU Medical, and then went on to Harvard Medical School. He is board certified in psychiatry and also has a JD. He's been a faculty at Harvard Medical School for 25 years. He still teaches seminars and things like that. He is board certified with the American Board of Psychiatry and in good standing, and he completed his residency in 1977. So that should give you some idea of how long. I mean, this man has been at this a long time. Long time. He is a well-known expert in psychiatry, research in memory, in mental illness, and the effects of solitary confinement. So, with respect to his testimony about the psychiatric effects of solitary confinement, the reason why he occasionally has cause to testify about that is because people who have been in solitary confinement suffer terribly for no good reason, and based on that, courts have found rights violations. There was an objection to this that was sustained. So this testimony, he's given it in a variety of contexts, and it can take a whole bunch of different forms. He testified one time he was hired by a federal defender concerning a terrorist, a suicide bomber. I guess didn't suicide, but a bomber who ultimately he had been working with the FBI, and he had initially been cooperating, but then they started to treat him harshly in solitary, and he shut up. And so in this case, the expert worked hand in hand with the FBI and with the defense to try to get him, his treatment improved to where he would resume cooperation. He's been involved in research and lawsuits involving solitary confinement. He's evaluated several hundred people who have been in solitary confinement. On a daily basis, he has a clinical practice in his home, but then he also does forensic work, and he does pro bono work for New York State for the government, where he reviews mental health records of inmates and gives opinions about those records. He gives lectures in bioethics, among other things. He doesn't remember the specific, actual words Mr. Rosie used when the team reached out to him to request that he work with them. But he was generally aware that Mr. Allen had made some seemingly incriminating statements while he was in solitary, and there was a question about the impact that solitary confinement had on his mental state. So he reviewed Dr. Westcott's IME report. This is the Independent Medical Exam. It's the acronym they've used before. So Dr. Westcott's IME report, medical and clinical records, videos, a variety of other records, phone calls, the interviews of the guards and the inmates who heard the statements. He reviewed these for the period of November of 2022 to about April or May of 2023. And then he also obtained some additional information from Wabash Valley up to February or March 2024. So asked if anything stood out about his statements, Dr. Grassian said, "No doubt Mr. Allen was," and Ms. Diener then objected and requested a sidebar. Interrupting the experts is going to be a theme of the day. This is something that the state has adopted as a cross-examination technique with experts, and it was very ineffective. It did not work. But this was just the first time it showed up. This, I believe, is the point where the line was drawn that we weren't going to be able to talk about Mr. Allen specifically, even though, obviously this case is about Mr. Allen, and the relevant thing is his mental state. We kind of got stuck after we got back from the sidebar with a whole bunch of very general testimony. So that's just kind of my impression that we got, that as soon as the doctor wanted to talk specifically about Mr. Allen's statements. There's an objection. And so when we come back, we have to move on to something else. And so what that is let's talk about solitary confinement. Starting by what does it mean? He describes it as when an individual is held in a small cell. It's typically 80 to 90 square feet, somewhere in that ballpark, with limited opportunities for physical stimulation, minimal social contact, and limited occupational opportunities. He describes it as very lonely and toxic, that people can become psychotic delirious. And he says, like I believe he has been in these videos, gets cut off again, objection, and that objection is sustained. Don't get to talk about whether Rick Allen was delirious in the videos based on the observations and opinions of an expert. I guess only COs get to talk about that kind of thing. Only prison guards get to talk about what does it look like when he's behaving like this. He's faking. That's okay. He's delirious is not. You make sense out of it because I can't. He agreed that he was allowed to testify and agreed that the conditions that Richard Allen was held in did meet those standards. Ms. Dieter objected at this point. She wanted to ask some foundational questions. So asked what is his familiarity with the conditions of confinement that Mr. Allen was in. He starts to say, well, it was a small, barren room. There's nothing to do in it but to read the Bible. And, the window you can't see out. And he's going through this list. And Ms. Diener tries to interrupt him and cut him off to say, well, you've never even visited. But he just continues talking over her, which I loved. I love that. I wish every expert would do this when the state cuts you off. Just keep talking. Just keep talking. Like, don't give them the floor. Just keep saying what you have to say. So he got through his list of things. I couldn't catch all of them because they were talking over, she's talking over him and so I couldn't all hear it. But ultimately, small cell, nothing to do but read the Bible. She confirmed, yes, he confirmed he never visited that particular facility. And so the sources that he relied on, videos and things like that, considered them, pretty reliable sources. Ms. Diener confirmed that he saw a video from Mr. Allen and is familiar with what the video shows of the cell. So with that, there was no really objection that followed on from that. It seems like sometimes these foundational questions that they use are just efforts to kind of pre-cross, break up the direct and get a little early cross in before it's really your turn. He was asked, what are the international standards affecting solitary confinement? So the doctor said they're not regulated. Solitary confinement is not regulated by any international agency. However, the UN considers solitary beyond 15 days to be a form of torture. Ms. Diener objected to this, saying, well, it's not relevant. International standards here aren't relevant. They're not binding. All that's relevant in this case is the Department of Justice policy. So now we're back and forth. Are we talking general? Are we talking specific again? Mr. Rosie said he's the expert, and these international standards would show the inadequacy of the DOC standard that Mr. Allen was being held under. So the judge doesn't specifically rule on this. He just kind of continues. He improves his foundation, shall we say. So we established that the UN recognizes solitary confinement as a term of art. And the doctor clarified, because he was trying to kind of interrupt during this, that I don't think you understood what I meant, which is also a common theme when the state is trying to cross-examine the witnesses. He says, what I'm trying to say is that they don't have any authority to impose their standard on any jurisdiction, which is correct. The UN is a voluntary organization. Any country gets to choose basically what and which standards they're going to adopt, comply with. And it's usually done by, treaty and compact types of processes. So the answer stands. According to the UN, solitary beyond 15 days is considered a form of torture under international standards. So in extreme cases, people have become delirious, confused, their memory disappears. Sometimes people have no memory of parts of their confinement. Smearing feces is unfortunately common, as is acting out sexually, being naked. And these are some of the effects that are about as bad as it gets. Although in some situations, you can see a serious injury and death. People will commit suicide from being in solitary. What happens is that people experience loss of memory, loss of attention. They become hypersensitive to stimulus. And there's about a 7 to 9 times greater risk of suicide in solitary confinement than in the general population as a whole. He defines delirium as the inadequate ability to maintain a state of alertness. He describes it as like having a fog or a thick soup in one's head where nothing makes sense and it's very bewildering. There's 2 ways that it can be caused generally. One is by internal factors. He uses the examples of severe sepsis, a respiratory failure, or it can be by inadequate external stimuli. He used the example of people used to be treated in iron lungs in like this, breathing machine when their lungs wouldn't function, and that this would be a major problem, that ICU psychosis is a thing. And that people with cataract surgery can also start to experience hallucinations and things like that. And it's all because it relates to a lack of external stimuli. If you are locked in a metal, breathing container for a long time, it's going to drive you insane. He listened to phone calls of Mr. Allen, Rick's phone calls, and when asked if he observed any indicators of delirium, a perfectly legitimate question, Ms. Diener objected to relating the testimony to Mr. Allen's phone calls specifically. Right now, that's a problem. We can't now talk specifically about Mr. Allen. So Mr. Rosie said he's reviewed everything. He has a foundation regarding symptoms that are consistent with delirium. And so he was allowed to answer that, yes, he absolutely saw symptoms consistent with delirium, the lack of memory, and becoming very frightened. And he said that this was an absolutely classic presentation. We then moved on to talking about false memories. Many people develop memories that are not true, but experience them as true. He describes false memory after being reviewed over and over in a person's head. It can start to look like a real memory. False memories, he describes as how the origin, that they don't start as images, they start as beliefs. And so you can look for clues such as things like, I think I saw something, and then they start to work that over in their mind, and eventually that becomes a memory. When you try to think about something from a long time ago, he says you're actually remembering the last time you remembered it. You're not remembering the thing, you're remembering the rewriting process that your memory goes through as you do this review. He says, so when people say, I think, when they're describing a memory, what you're seeing is a memory being created, and that he absolutely saw symptoms of that with Mr. Allen. That was all of his direct. It was effective, but he actually, I think, even scored more points on cross, which is not really how you want your cross to go. So Ms. Diener handled the cross and started by addressing the study that he had referred to, where they're reviewing something over and over in your head. And she said, what did you provide them to review? And the doctor is stumbling. He's like stumbling. He's befuddled by this question. He says, I didn't provide them any. I didn't provide them anything. This involved the lack of memory. And then Ms. Diener interrupts his answer because he's starting to explain the study. I'm just trying to ask a very specific question. She cuts him off completely. Judge allows this. What did the subject review that became a false memory? And the expert's like, no, you're confused. This is not our study. Our study was of prisoners who had no memory of a traumatic event, and they later developed a traumatic event, traumatic memory. Some of those individuals later retracted that memory, and others did not. And so they were interested in evaluating the difference between those who didn't recant and those who did. This is like a great big oops by Ms. Diener. Like, you don't take on an expert on his own ground, an expert who has been an expert for, 40 some years. You don't take them on their own ground because you're not as smart as you think you are. And unless you have your own expert who is like in your ear telling you how to go about what it is that you're trying to do, you're going to bomb, and you're going to make yourself look stupid. Like this question did. So he explained that people who recovered real memories, those memories would be sensuous. They would be associated with a smell. They would be associated with a sound. And the difference with people with false memories is that those would begin with a belief. I think something happened. I believe something happened. Maybe something happened. So he says real memories are perceptual. And so now Ms. Diener is trying to draw, like, it's very transparent what she's doing. She's trying to draw a connection between the language that he's using and how she wants to characterize the confession that Dr. Waller wrote in the notes that is attributed to Rick. First off, as if it is Rick's language, which, Dr. Westcott yesterday called significantly into question. But also now kind of putting her own spin on like what that statement consisted of. So she's like, okay, so real memories are perceptual. Does that mean like being able to relate events to feelings? And the doctor says, well, no, that's not intrinsic to it. That's kind of a different subject. And she's like, well, maybe, maybe means about how events are making them feel, or how their insight with it, their ability to be linear, stuff like that. And he says, he's like, he can't keep up. He's giving her that look. I don't know what you're after. She's like, I'll move on. Yeah, that went nowhere. Asked if he was aware of critical factors that are at issue in safekeeping. And he says, I'm aware. I'm not an expert in prison administration. And she asked, do you distinguish between solitary confinement when it's used as a punishment and when a person need to be kept in a one-man cell as a safekeeper for purposes of their safety? And so the doctor explains that you often see people held individually, but they are typically allowed things like joint recreation with people, like a small group of people who will be other safe people. And that the psychiatric difference depends on the conditions to which they're imposed. It is independent of whatever the legal justification is for the confinement. That seems quite obvious to me. You're not going to not become crazy because you're like, oh, my solitary is legally justified. I mean, it was really bad. This was the whole cross. And it was just a bomb. It was a big old stinker. Couple of jury questions we had here. Do you believe psychotic behavior can go back to normal behavior after being removed from solitary confinement? And he said, generally, yes. He then starts to try to apply this answer to Richard Allen. In the case of Mr. Allen, there's an objection, and that is sustained. So can't tell the jury how this would apply in Richard Allen's situation, which is kind of unfortunate because, right, that's That's one of the things the state's trying to put the thumb on the scale with the February 24th over in Wabash. And he reviewed all that stuff. That's part of why, he reviewed it to do this evaluation, so that he would be able to talk about, are these types of things consistent? Are those conditions the same? So on and so forth. But when it comes to talking about him specifically now, they're not going to let him do it. Question 2, do you believe a completely normal person can become psychotic after 6 to 12 months in solitary? And he says, absolutely. I have seen it happen. So not a whole lot of equivocation in that response. I guess I blocked out my memory of the morning because Mr. Rosie also handled Dr. Eric Warren, who was the next witness. I didn't remember this. I don't know why. I guess maybe he did need his look at me tie. Maybe it was appropriate today. Dr. Eric Warren is from near Memphis. He has a company called SEP Forensic Consultants. They regularly consult in various aspects of forensic science, including firearms analysis and crime scene reconstruction. His background is a bachelor's in molecular and cell biology, a PhD in biochemistry and molecular biophysics. These are very intimidating words to me. He started working with the Tennessee Bureau of Investigation, the TBI. He was a special agent forensic scientist in the Firearms and Toolmark unit. He did a two-year training program, that's the AFTI training, and then did casework until he left TBI. He was also on the violent crime response team, where he would respond to crime scenes and be involved in evidence processing. So he was a law enforcement officer. He said his background was research-based. Basically, the reason why he left, he had a research-based background. He was interested in looking at the effects of external things on bodies. And so in the lab, the problem is that your focus has to be on casework and on turning over your case assignments. So they don't have time to dedicate to doing research. And so that's basically the reason why he left. He wanted to be able to pursue his research interests. And to do that, he set up his own independent practice. He is an active, distinguished member of AFTI. He is on the board of directors of AFTI, and he is certified by AFTI. He is also an editor of their journal. He's testified for both the state and the defense around the U.S., whether in firearms analysis or crime scene reconstruction. He's also testified in civil cases. He's provided training to law enforcement. He talked about a mentoring program he did when he was at Vanderbilt that was basically about how to properly perform scientific research. So like how to set up a study, how to do your documentation, how to do, reach proper conclusions and things along those lines. He had just got back recently from Morocco because he was training a bunch of new firearms analysts over there to meet the AFTI accreditation standards or certification standards. Asked about whether or what is the critical community concerning the legitimacy of this discipline, he says that the community is professionals who are not necessarily firearms analysts, but they are in a related field. Professionals in those areas have opinions that are critical in evaluating the firearms analyst's work and what they do. He says he has testified a few times against them, defending our science. He acknowledges the PCAST and the NAS criticisms. He is familiar with them. His position is that those types of criticisms are helpful in advancing firearms analysis because when you can have a constructive dialogue, it's essentially peer review. Yeah, I'm totally on board with this philosophy. Respectful disagreement makes everybody better. It gives us all better ideas. We have to think harder. If you're always in an echo chamber and nobody ever disagrees with you, then you can have sloppy thinking. You can get very lazy in your thinking because you're never challenged to defend your perspective. So he feels it will generally only push a theory forward because, they can take those critiques, they can design research to address those questions, and ultimately just improve the discipline based on that type of input. So the scope of his work in this particular case was to review the ISP examiner, Melissa Oberg's work product and her conclusions, and to determine if the basis for her opinion was properly documented. So he reviewed her case file, three related firearms as well, 3 related comparisons, looked at the microplates of the comparisons, her deposition transcript, and felt that it was enough for him to be able to generate the opinions that he was asked to provide. There was also nothing that he did not receive that he would ordinarily expect to receive for this type of analysis. Micro photos in particular, the microscopic photographs that they use to show the side-by-sides. He says you would ordinarily see them in the case file. It's one aspect of documentation. He talks about documentation being important, one, because the examiner might have a gap of many years between the time they do the work and the time that they testify, so it refreshes them. That's what Ms. Oberg said it was for. But he said another is for accreditation, that there are requirements for the work product to be sufficient for another to be able to review it and understand why you reached your opinion. Yeah, that's replicability. That's a basic scientific principle. If you don't document your results and you just say whatever, you think subjectively the answer is, well, that can't be replicated. So you have to show your work. That's part of the scientific process. And then finally, it's also to be able to illustrate exactly what they observed to folks like the folks here on the jury. So contrary to what Melissa Oberg said, that you can't look at the photos and you shouldn't look at the photos because they don't, it's not right. It's not what they're for. He says, no, that's actually specifically one of the reasons why they do that. And I've seen a lot of these photos come up at trial. The state themselves put these photos in at trial. So this is very odd position that we take all these photos to document, but nobody can look at them. They can't actually mean anything. While at the same time, they really want us to look at those photos. He addressed her testimony about the argument that this is problematic because the photograph is a 2D depiction of a 3D object. And he says that's not correct. That the microscope has a very narrow depth of field, so it's a very thin slice of what's in focus. Depth of field is like how tight your focus is in. If it's very, very narrow, the focus is tight, and then everything that is outside of that field begins to become blurry. If you have a wide depth of field, then everything within the frame is in focus. So it's a very narrow depth of field. It's a thin slice of what's in focus, and that is what is being projected through the microscope. And so the examiner is always seeing a two-dimensional thing because of the images that are being being. I don't know, I guess what the right word is there. They're just seeing the images through the microscope, and it projects it as if it's flat. So he says the process is more like it's like a movie because it's like watching several frames. You can rotate the items, you can see the different fields. So the problem is not that it's a 3D object that we're trying to make 2D. That's not the issue. He says the need for photographic documentation, the importance of it, has been recognized in the field since the 19th century. It's just part of showing your proof of your work. So you're supposed to photograph the things that you are relying on to reach your conclusions. All standard textbooks talk about the importance of photography for this reason. He says, I have all the time that I need to take the best photo that's representative of what I saw, to make sure the light's just right, the focus is just right. And so that is the point, is to create a good representation of what you see that you are relying on to draw conclusions. We revisited the general broad categories of the class characteristics, subclass characteristics, and the individual characteristics. They're similar definitions to what we heard before. His example was if you have a buck pocket knife, you use it as a screwdriver and that causes the blade to chip. Anything that you would cut after that would show a gross cut. And so the subclass is essentially this type of thing when it happens during manufacture. And so it will, when it's a subclass characteristic, that means that feature will then carry over across multiple firearms until whenever the tool that is being used to create this particular item is replaced. He watched the 5-minute video of the Sig Sauer plant that we all watched, and he said, I did not see any relevance to that. It did not discuss the tooling or the tools that left the marks in this particular case. It focused on the slide and in the frame, and the details for the internal components, which are the ones that are relevant to this case, were not mentioned at all. He testified that there have been labs recently shut down because of inability to distinguish between subclass and individual characteristics. That the Rhode Island crime lab was suspended about 2 to 3 months ago. And another lab, I thought he said Arizona, but he might have said Alabama. Can't totally remember for sure. That one was shortly before, also got suspended shortly before that. So this is seeming to be a little bit of a problem in the discipline. They can't tell apart the things that are distinctive and individualizing and the things that aren't. And so what that means is that you're calling a lot of things matches that are not matches. And when you're matching guns to things that they don't match, you're probably sending innocent people to prison. So yeah, that's not good. These labs should be suspended if they can't do that. We then address the cycled versus the fired rounds. So with an unfired rounds that's been cycled, that is specific to a semi-automatic gun. It uses machinery that if the gun was fired, those tools would extract the shell, eject it, and reload the chamber. So when the gun is not fired, but the cartridge is loaded into the chamber, you can remove the magazine and pull the slide to extract the cartridge. And that, in that case, may leave tool marks from the ejector and the extractor. This is very different from a shell that goes through firing. There is a lot of pressure on the cartridge as well as pressure on the ejector and the extractor. He's familiar with item 16, which is the unfired cartridge collected from the scene. He's familiar with several firearms that were collected and processed in the lab. There was a misspeaking here because they originally were talking about item 315 as being Rick's firearm, but then ultimately, Mr. Luttrell just objected, said, I think he misspoke, that it's 314. It is indeed 314. So they corrected that. Asked if it was appropriate to examine cycled bullets with test-fired rounds, he says, well, it is done, but it depends on the question that needs an answer. Because the firing will create differences in pressure and the time of contact with the item. So generally, you want to see apples to apples. You want to compare unfired to unfired. And part of this is because there has been a study of the angle and pressure of tool marks that other agencies have performed these studies that show that even a 15-degree difference in the tool can change the appearance of a tool mark. So yeah, you change the conditions, changes the marks that result from that. So in that case, they found it was impossible to ID two items that were from the same source, that were known to be from the same source, just due to the differences in the pressure, how that can change the marks that are left on the item. So because of that, you want to compare with the closest thing you can find, and you cannot know that that is the case with a fired versus an unfired cartridge. He notes that Ms. Oberg was unable to create marks from the cycling dummy rounds. Mr. Luttrell objected at this point, saying she testified that she used both. And then he asked for foundation. Did she use the cycled test round to draw conclusions about number 316? And the expert says no. Her notes indicate she the hard cycled round marks were not prominent if they existed at all. And so her conclusions relied primarily on the fired rounds. He is not, in this case, okay with that process. It was not okay. And so the reason why is because with tool marks, you have to prove that they are repeatable and reproducible. So, for example, in another situation, there was a gun where you could show repeated and reproducible marks across fired and test fired rounds. But that was not the case as to this gun. As far as error rates, there are no studies related to comparing cycled rounds with unfired rounds that would establish any kind of viable error rate for that. He turns to Ms. Oberg's findings. So the tool marks, 3 of them that she had focused on that led to her identification were marks from the extractor, the ejector, and the chamber face, which he generally calls the barrel hood. So we have a new name for that one. According to him, the ejector showed indicators of subclass marks. Mr. Luttrell objected at this point and said, well, isn't it true you can't really answer this question? You've never seen any of the evidence. So you can't really answer these questions since you haven't examined the evidence yourself. And the expert says, no, that would be incorrect. I have reviewed the entire case file, the macro and the micro photos, and that those items are adequate for the conclusions that he is drawing. Sit down, Mr. Luttrell. So first with the ejector, he says she documented the ejector quite well, both the tool itself and the marks left. When compared to item number 16, the cartridge, she noted that the machining surface had a high potential for subclass. And so certain types of manufacturing processes, he explains, certain types of like machining and tooling and stuff like that, have the highest propensity for subclass marks, and you cannot rely on those subclass marks for identification. With the extractor, she did not document any evaluation for subclass in her work. There are lots of articles out there about extractors that they lend themselves to subclass marks, and there does not appear to have been a direct examination of the extractor itself. I believe you might have to disassemble the gun to be able to do that, but she did not do it. And then the barrel hood, he said there's even less research regarding it because it is not a tool mark that is typically used. It's not one he's ever heard used before this case. Barrel hood mark, first time he's ever heard of it being used. So there's no research compared to the research there is for other components like the ejector, the extractor, the breech face, and the firing pin, which are very common sources of marks that are used in these identifications. He said it is possible there was potential for subclass characteristics as to all 3 items. So she only evaluated 1, but there was potential for subclass characteristics as to all 3. It was possible to draw conclusions regarding individual. It was not possible to draw conclusions about individual characteristics from her work in this case unless you have done research into the subclass characteristics so you can extract those out from the marks that you are using for the basis of your comparison. And in this case, she only did that for the ejector. We looked at The defense exhibit that showed the comparison with the Testfire 2, he said there were 13 or 14 photos like this that he reviewed. The tool mark itself that we're looking at is a triangular ejector mark, and he describes it's created because the cartridge is drawn forward. The ejector is a stationary pin, so then it's pulled rearward with the extractor, and that causes the cartridge to pivot and eject out of the ejection port. So he describes on the photo there's a hairline in the middle, and that's from this combined microscope tool that they use. So it separates the left from the right portions. The right side of it is the test fire from item number 250 or 315, the Rick's gun, and the left side was the cartridge from the scene. So he walked us through this photo a little bit and showed that there are lines that cross over the hairline, and that's, essentially what you're looking at as the point of comparison. That's what the photograph is attempting to document, is that these lines are common, and so it looks like they just cross right over the hairline. He says, we use an oblique light that's not a direct on it light. It's an oblique light, and so what that does is it lights up the high areas and creates darkness in the low areas. He describes one of the ways you can identify subclass characteristics is that they appear as gross marks with a uniform spacing. So by gross marks, he just means big. He means like thick, and they all have uniform spacing. And so he identifies on that photo that both of the things that you can see there are hallmark examples of subclass characteristics. So what he would do if he was doing a comparison is he would take those out of the equation, and then you would look at only the finer marks that were in between the two items in the middle. And if you do that, looking at the photo, they do not match for sufficient agreement. So we kind of reiterated that the Rhode Island lab had problems with distinguishing between these gross marks and the finer marks when it comes to the whole problem they had with subclass versus individual characteristics. Mr. Luttrell objects at this point that the Rhode Island lab doesn't have anything to do with this case. It's irrelevant. Mr. Rosie argues the comparison has a tendency to prove that these marks can be deceptive, and the judge sustained the objection. Don't get to talk about Rhode Island anymore. We then talked about CMS. CMS stands for consecutive matching stria or striations. One of the key critiques of firearms analysis, which is pretty much my main one, pretty much my main critique of it, is that its standard, as the standard is written, it is sufficient agreement of individual characteristics. This is a subjective standard. What is sufficient? It's up to whoever's looking at it. So what this CMS system does is it attempts to provide an objective standard that sets numeric criteria as like a floor to be able to obtain a conclusion of whether there is an identification or sufficient agreement. And so what you do in this model is you look for 2 runs of 3 consecutive matching striations or 1 run of 6 consecutive matching striations. And if you can find those things across both of your characteristics, then you can confidently identify the item. Mr. Luttrell objects again. He wants to do some foundation. Are you aware that ISP doesn't use a CMS? He says yes, and that most labs don't. The witness disagrees. He says a subset doesn't. It's not a different examination. The foundation is the same. He's willing to say that some don't use it, but he doesn't think he could say that, that most don't use it. And Mr. Luttrell said, and you don't use it in your own lab? And he says, yes, I do. And Mr. Luttrell says, since when? And he says, well, since I had some training, remember in 2022 or 2023, some guy named John Murdoch. And Mr. Luttrell says, well, I didn't see it on your CV. And he says, yes, sir, it's right there under the list of training. So maybe, Maybe read the thing. Maybe read the thing like before. Plan this stuff out. You got to plan your cross out. Don't be trying to do this on the fly. You're going to misread a CV. It's like 20 pages. CVs are long. They have a short sidebar at this point. Then when they come back, he's asked if the CMS process is one that AFTI has recognized. And he says, yes, it is not part of their own standard, but since 1959, it's been established. It minimizes subjectivity, and that is one of the major critiques of the firearms and tool marks comparisons discipline. Yes, indeed it is. It is really one of my major critiques of it. So generally, you photograph and you tabulate the individual striations that are in agreement that you are relying upon. And so he used her photographs to then calculate the CMS. He found that the extractor had one run of 4 striations, which does not meet the threshold. The barrel hood had no consecutive runs of striations, and the ejector, if you take out the subclass marks, had no consecutive runs. And so based on his conclusion, there was insufficient agreement between the items to declare them to be a match. So basically, he believes Melissa Oberg is wrong, and that regardless of the criticisms of tool mark analysis, you have an objective standard you can rely on, and even applying that, her comparison does not meet it. We took our recess, and when we came back, Mr. Rosie had some omitted questions to ask. First, the slide on the handgun concerning the amount of force that is needed to rack the slide. That is part of the manufacturer's blueprint characteristics. The amount of force required is dictated by the recoil spring that gives tension and that creates the force to be able to rack the slide. Asked if there has been any research on the integrity of the slide. He said not really. As you break in, the spring can get weaker as it's broken in, and that would cause a little bit lower force required to be able to rack the slide. You could look at the surfaces of the slide itself, but not the force required to rack the slide when it comes to looking at persistence. And so there have been several studies on persistence, but they are just looking at the metal surface. And across the whole thing that we heard before from Melissa Oberg about the persistence across 10,000 rounds, that basically if you fire a firearm 10,000 times, the marks that come out of it the first time will still persist to at least 10,000. And he said as many as maybe 20,000 rounds later. So not a lot of variation in a short period of time. He agreed that the Sig Sauer that Rick possessed is considered a high quality handgun. It's in the upper tier, or at least mid to upper shelf. And that the integrity of the slide should persist. An exception to that would be corrosion, but he did not see any indication of that in the photos. We then had Mr. Luttrell's cross. So first he asked him about the mechanical fingerprint. Have you used the expression that the firearms is like a mechanical fingerprint, the comparison? And he said, yes, he's probably used that term with the TBI. That was the term that they used. Asked, he did not prepare a written report. And he said, no, that is not something that came up in the context of the case. I'm just going to go ahead and explain that part of the reason why no reports will often be prepared for a defense in the case is because many of the rules of discovery say you have to turn the expert's reports over as part of discovery. So if the expert doesn't create a report and they just call you on the phone and tell you what their results are, that's not something that has to be turned over in discovery. And particularly in a place like Indiana, where basically the discovery obligation, if it's not in the rules as a mandatory disclosure, then it's on the other party to go in and take a deposition. So if they want to know more about his conclusions once they know that he's going to be a witness, it's really on them to follow up with that. It's not the defense's burden to make him create a report just so that they can hand that over to the state. In other states where I practice, for example, in Washington, you typically will have to disclose the substance and bases for the expert's opinion, regardless of whether there is a report or not. So you can't just not disclose anything at all. But it's nevertheless kind of the same situation. You want the bottom line. The expert can communicate that to you, over the phone. You have to communicate the bottom line to the state. But for discovery purposes, you don't put everything through in a report because you don't give the advantage and the time, the luxury of time to be able to just go through and sit and nitpick your work. So it is a little bit tricky. I'll acknowledge that it's a little bit tricky, but it is how the rules are written. And if they want to change that, they should change the rules. So as it is, we do not have an obligation to make our experts produce a written report. So he agreed that individual marks would persist in the absence of gross abuse of a firearm. And so, yes, the first bullet would be would match the 10,000th bullet fired, or maybe even the 20,000th bullet fired. You would expect a decently maintained firearm to produce consistent marks, even if frequently used. Subclass marks, these are not a new concept. They have been studied for maybe 90 years. Early on, they were known as family characteristics. He described at issue here, if you were talking about class characteristics, what you would be talking about for class in this context would be the relationship of the extractor to the ejector. And so it's rather like a clock face. If you look at it like a clock face, you would have the extractor mark at approximately 3 p.m., the ejector at approximately 7 to 8 p.m. And so it's the relationship, the orientation and configuration between those that creates the class. The subclass is produced by the manufacturing process. It can persist, he says, for 10, 100, or 1,000 or more firearms that are made by the same tool. So whenever something is producing these firearms, it's creating the same patterns on them until you swap out that tool that is making those firearms. Mr. Luttrell says, well, you use different tools to make different parts. And the witness says, well, it can take different tools. But since the advent of CNC machines, which is like the computer guided machining stuff, a lot of tools can be fabricated on the same tool. He doesn't know if there is a different tool that makes the ejector and the extractor with the SIG, but he would expect them to be different tools. He would probably expect the barrel head to be made from a different tool than was used to make the extractor or the ejector. I'm really not sure why this matters, because we're comparing ejector to ejector and not ejector to extractor. I'm not sure where this is supposed to be going. He confirms that the assembly of a firearm, it is done by hand. So the components are typically stored in a bin of just that lot of subparts, little subcomponents that you're using to construct the gun. So they get a lot of extractors, and they dump those into your bin, and then you sit and then you put guns together using what's in that bin. So the subclass, he then, Mr. Luttrell describes it as like a funnel. So he adopts that definition. And Mr. Luttrell says, if it's a funnel, then you're getting way down there by the time that we're distinguishing subclass and individual. And the witness says, no, I would not agree. It could fall anywhere on the continuum from the top to the bottom of the funnel. He agrees that sequential serial numbers might not share the subclass. And this is, again, partly relating to the manufacturing process, because you can have, different lots. You can have different lots all in your bin. You're not necessarily going to clear out the entire lot and make this gun. You're just probably going to like refill your bin as it becomes available and stuff. So it's not, they've, documented that. Sequential serial numbers don't necessarily share the same subclass. And he says, yes, that is exactly why the documentation of subclass characteristics matters. He confirmed that he started his training in August of 2009. He left TBI in August of 2017. Said he would always consider the potential for subclass characteristics. Ms. Oberg, he's asked, said she had concerns about the subclass on the ejector and she pursued it. And he says, yes, she. So here's the question. This is where things start to get bad. So Mr. Luttrell has been like kind of aggressive, and he's doing the smarmy thing that McLeland has done before, where he's just trying to be snotty, and it just doesn't work very well because a lot of the times he's wrong. He tries to be snotty, like thinks he's got this great point, and he's trying to be snotty about it, but the witness is like, no, no, that's not it. And the witness is staying very calm and polite under all of this. So Mr. Luttrell asks him, isn't it true she did not articulate any concern about subclass marks on the extractor and the chamber face? And he answers and says it's not documented that she even considered it at all. And he's in the middle of this answer when Mr. Luttrell interrupts him, says, that's not my question. Answer my question. She didn't articulate any concern about extractor and chamber face. And this time he says, there is zero documentation of any evaluation. So there's no way to know if there is a concern. And Mr. Luttrell is mad again. He's not answering the question. Asks him again. Mr. Rosie objects to it being asked and answered, which it is. He's answering the question. When he interrupts, Mr. Rosie is asking, let him finish his answer. It's asked and answered. Luttrell's like, it's a yes or no question. He hasn't answered it. And it's overruled. He's literally like yelling, he's not answering. And the judge says, sir, you have to say yes or no. She's never told not a single one of the state's witnesses that they have to answer the yes or no question, yes or no. They get to answer the question how they want. So we go through this twice more. Didn't articulate any concern about subclass marks on the extractor and ejector face. He keeps trying to say it's not documented. And the judge says you have to say yes or no. And he's like, well, that specific question, that answer is no. He's made his point in all this. Now, it's during this exchange that there is an incident that I cannot confirm. I am very sorry to tell you, because I saw, when I got off, some people had heard about this already on the social medias, that one of the jurors shouted at the judge, "Would you just let him answer?" So I myself did not hear this. Didn't witness it, didn't catch it. There was like a lot of shouting going on already because Mr. Luttrell, he's literally shouting at this witness and, talking over him. And the witness is trying to, say his answer. So there's like a lot of noise. I didn't hear this. I will tell you, I did have two separate people tell me that they heard it and they saw it. Like one of them sitting next to me was like, I just happened to be like looking over at that direction. I looked up at the juror just as he was doing that. So that's my account for you. Can't say myself that it happened, but heard from a couple of other people that, in fact, it did. At least one of the jurors did not like how this witness was being treated. Asked if he knew how much experience Ms. Oberg had. He said no. And would it surprise him if she had more experience than he did? And he said, not particularly, because time doesn't really matter. The time that she's been doing it doesn't really matter. Yeah, it doesn't. The quality of her work is really all that matters. Mr. Luttrell asks, would a firearms examiner do research all the time? And he says, well, no, if it's routine research, like if it's a routine examination, nothing complicated, then they would not need to do research. Well, does FT encourage research? He says, well, no. I mean, they do encourage it generally, but not necessarily from one case to the next. So then he asks, are you suggesting she forgot to consider subclass characteristics? And the witness says, well, it's possible because she didn't document anything. You don't know. You don't know what she did with subclass characteristics because she didn't document anything. So Mr. Luttrell is now like, well, do you document every single little bit of your knowledge and experience and all of your training that you've had over the years? You document all of that in your findings. He's really sounding like a jerk now. Like, I mean, it's been bad up to this point, but he's just like really getting extreme. And the witness says, no, as I testified, if I do specific research that's related to a case, I put that in my report. So this is Mr. Luttrell. He's trying to push back on that cross-examination of Melissa Oberg that, she claims now that she was relying on these old studies that she had reviewed when she was like in training, but hadn't made any sort of reference to that in her report. And his point is basically just saying, well, no, of course you don't have to put your entire history and training of everything, but if it is relevant to the conclusions that you're drawing, then yes, you would put that research in your report. According to Mr. Luttrell, Melissa Oberg identified 3 tools that produced marks on the cartridge, based her opinion on those 3. And so the fact that it was 3 did that strengthen her opinion that Mr. Allen's gun cycled the cartridge. And Mr. Rosie objected to this as to speculation about what's in her mind. And so he rephrased it as, the fact that it's 3 tools making distinct tool marks, does that strengthen the result? And the expert says no. There is subclass agreement on the ejector only. There is some insufficient agreement on the extractor. There is no agreement on the barrel face. So I thought it was sufficient. Here's a little bit of a problem. Apparently, in Melissa Oberg's notes, her work, she says she found some agreement between the things. And Mr. Luttrell says, no, don't you mean she found sufficient agreement? And he says, no, actually, her report says she found sufficient agreement, but her work file doesn't. It just says she found some agreement. Some agreement that got escalated to enough to meet the standard when it came time to write her report. Well, that's not a good thing to elicit in your cross-examination. That's not a good thing at all to elicit in your cross-examination. Mr. Luttrell then says, isn't it true a tool mark is a tool mark, whether it's in cycled or fired rounds? And the witness says, no, that is not correct. And he says, well, the task is to see if fired creates similar markings as the other one, if firing the round creates similar markings to the other one. And the witness says, as I said, it's about reproducibility and repeatability. So no, you're not trying to get an outcome of marks on a round that match by doing your process. You see the problem here. You see how that's kind of reversing. That's reversing. You need to have the marks to start with, and then that drives your comparison. So he asked if the test examiner could determine that the test fires are adequate for comparison, and he says in this case she could not. So Mr. Luttrell says, well, the test-fired cartridge was suitable comparison. And he says that was her conclusion, yes. And Mr. Luttrell, he thinks he's got a real gotcha here. Well, isn't that, you just did that in front of this jury right here. You demonstrated that the documented tool marks were suitable for comparison. And the witness said, no, sir, I didn't testify to the suitability of anything. I looked at a photo and discussed the marks I saw. He's just staying very cool and calm under fire, really, really handling this, just being berated very well. So then he starts to get confronted with statements that he made apparently in a prior case in 2021. And so he's asked, in 2020, didn't you testify in 2021 that you didn't use the CMS methodology? And he says, in 2021, I probably testified I didn't use CMS in that particular case. And that's because it only works for striated marks. It doesn't work for impressed marks. One of the common impressed marks that you use on shell casings when you're not talking about the projectile is the firing pin. That's an impression mark. And so if you're dealing with the firing pin mark, you can't use the CMS. He's continuing to try to explain his answer, and Mr. Luttrell objects again, and he interrupts him in the middle, saying he's answered, Your Honor. He's answered the question, Your Honor. He's crying to mommy in the courtroom because he doesn't like that the witness is giving a complete answer. I can't really express to you what a bad look this is. I'm noticing one of the jurors, the juror who is the juror I am told had the explosive outburst to the judge, just let him answer the question, doing that slow blink at Mr. Luttrell. He doesn't seem impressed by any of this, crying to mommy, interrupting him. He's answered. But you didn't even learn CMS until after 2001. He says, no, I received my most recent training in CMS in 2022 and 2023. And well, were you trained to use photos to make those types of comparisons? And he says, yes, sir. In training, that is exactly what we did. And it regularly occurs that you testify based off of another examiner's photos. So this is perfectly normal, according to this guy on the board of AFTI. So he's then, Mr. Luttrell is still trying to get at this. Well, didn't you testify in Flagstaff, Arizona in 2021? He's like, well, I have testified in Flagstaff. I don't know if it's 2021. And didn't you say then that you didn't use CMS methodology? And he said, well, it may not have been applicable in that case, but I don't recall. And Mr. Luttrell asked, well, don't you remember saying it's a West Coast thing? It's not done in the East Coast or the Central Midwest? And he says, well, yes, it originated in Berkeley. It hasn't migrated east yet, so most practitioners are still in the West, and there are some labs that don't use it. Haven't you said in the past you can't come into court and offer a conclusion based on photos alone? He says, I can imagine a situation where the photos were such that I could not reach a result based on those photos alone. So then he doesn't recall all of the specifics, but with respect to this Flagstaff case that Mr. Luttrell seems to be concerned about, he said that involved very soft bullets. And so just in that particular case, he would need to physically examine the bullets to be able to make a conclusion, just because of the nature of the comparison that he was being asked to do. It's probably like a lead bullet or something. So he says, I don't recall what specific words I used, just that I could not or would not make a source conclusion from the photographs that had been taken. Luttrell says, you're not an accredited lab. Your lab is not accredited. He says, that's correct. And they asked, have you tried to get there? And he'd say, I'd say we met the standards. And Mr. Luttrell says, well, sounds like you don't think very much of accreditation. And he says, you're right. I don't necessarily think very much of accreditation. You're paying somebody to look at your procedures and cherry pick 5 of your cases and look at them to see that they show that you're doing what your policies say that you're going to do. And he says, I don't have a lot of confidence in accreditation because both the Rhode Island and this is where I think he said Atlanta, both the Rhode Island and the Atlanta labs were accredited. That's an excellent point. Excellent point. Mr. Luttrell now shifts gears with this just very this is irritating, annoying question. What is the most important tool in firearms examination? What's the most important tool? Like how do you even answer that? Like what are you're trying to go somewhere, like thinking like you make a point, like like you're trying to be, I don't know, Socratic up here or something, and then you're going to debate my answer. Like what even is this? Well, he says ultimately after like thinking about this for all, I don't know. Well, I guess the most important tool in firearm examination is myself. And Mr. Luttrell says, well, but you would need a comparison microscope to make comparisons. So Mr. Rosie is objecting to relevance at this point, that these are broad and unclear questions. And Mr. Luttrell shouts, I'm going to ask everything in this case. And Judge Gohl overrules the objection. So apparently maybe shouting at the judge is the way to get her to rule for you. It was really out there. I have double parentheses at this statement. I'm going to ask everything in this case. Are you? Because I thought Mr. McClellan was just saying the other day about how that's all up to the judge. He says that the comparison microscope is simply a tool that is required to meet certain standards, but you could also use a 3D microscope, and there are many tools that you could use. He's then asked about the AFTI manual, and he says, well, I was trained at the TBI. Weren't you trained by AFTIs? Well, I was trained on the TBI manual, but that was based on the AFTI standards. And he says, I strongly recommend AFTI membership and certification for firearms analysts, but I don't necessarily recommend that the AFTI manual be used in any particular way. Now, he says, so a comparison microscope, you can just take it or leave it. That's what you're saying. And I'm like, Jesus, this is what is your problem? He's being so argumentative. This could easily have been an argumentative objection. They didn't make one. You could just take it or leave it. That's what you're saying. He's like, well, I guess so. Asked if he's ever said that you should let the evidence speak for itself. He's like, well, sounds like something I might say. I firmly believe that you should document the evidence to the best of your ability and present it to the jury. And yes, let it speak for yourself. He's then asked about his consulting business and how he advertises. And he says, yes, I have a website and an email and things like that for consulting. And services that I offer, like reviewing documentation. He's interrupted again at this point. You've answered the question. And you also do your own examinations. And he says, if requested, then yes, I can. When asked if you received everything you needed in this case, you didn't include a gun and a bullet. He says, well, I don't remember the specific discussion I had with the attorney regarding what I was being requested to review. I got what I needed within the scope of that request, and so I would not need to get specific items. And as far as doing a specific comparison, he says he believes that there was discussion about doing that, but he doesn't remember the specific conversation or that he had ever asked to do a comparison. He said it is simply an option. And I had a little star in the column in the margin here because my question I would have liked followed up on was, would they have the funding to do that? You know, the scope of what you're allowed to do with your expert depends a lot on what the court will pay for when you're dealing with court appointments. And as I recall from the pretrial motion where they were talking about, it was a request for parity in resources so that the defense could properly respond to the state's case. It's my recollection that a firearms analyst was denied. That Judge Gold said, no, you can't have one. So I remember it was in this time frame that there was the private fundraising to try to raise money to be able to hire defense experts. And I don't know how that ever turned out. I just remember it happening. So, you know, testing is super dependent on funding, the scope of what you're able to do. And that never got drawn out. I think that's very unfortunate. Because it's not clear to me that this was necessarily a decision that was entirely within the defense's control. But in any event, if he had received those items and created his own test fires, would he use his own comparison microscope? And he said, yes. If I were asked to compare and analyze physical items, I'd expect to use a comparison microscope. And Mr. Luttrell says, so no, take it or leave it there. No. In that situation, you would use the comparison microscope because now we're talking about something specific and not something incredibly broad and abstract, like what's the most important tool? We now have that same juror is now really slow blinking. And one of the other jurors turns to look at the clock. So they go back to the exhibit with the photograph, the side-by-side photograph, and says, isn't it true that very slight things can change the lighting, slight movement can change the lighting on this thing? And he says, no, sir, the surface does not change if the image or the light is adjusted. It is possible that the photo would look a little different if the angle and the light are adjusted. If it would look different, then you should take a better photo. That was finally, at long last, the conclusion of this cross. Mr. Rosie asked him about how long ago they started working together. It was over a year ago. And was he ever requested to generate reports? No, he did not. And did he make himself available for deposition by the state? He did 3 to 4 weeks ago. And that was all that Mr. Rosie asked on redirect. We had several jury questions for this expert. Remember, our jury seems to be very technically minded. So the first question is, given that there can be a change in the position and slight tools on a cartridge can change the marks, then how can CMS be used? And he explains that we would still use the same method. It's just that minimum change of 15 degrees it will create enough surface changes to be able to prevent being able to form a conclusion. That is what the study showed. Good question here. Does removing, reassembling, cleaning, etc. change the location of the markings? And would you need the gun for your testing to be objective, for the conclusions to be objective? And he said, no, these processes would not change the individual characteristics of the gun unless damage had occurred. Like if you're cleaning it and you drop something on the concrete or whatever, then that would potentially change the individual characteristics. But just the acts in and of itself of taking apart and putting the gun back together would not. Mr. Luttrell asks, he follows up on this, you testified that with the extractor, there is no photo of it. He said, well, it's visible in some of the macro photographs, but not like just like of the firearm as a whole. And so he says, you'd have to disassemble the firearm. Wouldn't that cause problems for a later examiner? And he says, no, like he literally just answered that. It doesn't cause any problem to take the gun apart and put it back together, as long as you don't drop pieces on the floor or do something else to damage them. Question, do you know if manufacturers keep track of subclass characteristics? And he said, no, this is not a manufacturer's thing. This is something that is done within the field of the firearms analysis. So it's just not the manufacturer's thing. They do not track that stuff. Question, what was the reason why you didn't do your own analysis versus just reviewing the documentation? This is where I wish they could have gotten into the funding, wish that could have come up. He says, our discussion was to explain the conclusion and if documentation supports it, and that this is a common process, and that he was not requested to do a physical examination. So that's basically the only answer that he got. Would doing your own analysis have been more conclusive? And he says, well, it's impossible to say really without having done the comparison. It's possible it could go either way. My testimony here is that the documentation is not sufficient to support the conclusions that analyst drew. Then he was asked, do you believe using the 1 run of 6 or the 2 runs of 3 is the gold standard? And is that the standard that you would use? And I did not catch his answer to this question because these were coming out. He just kind of gave an answer that was like reiterating what CMS was. That it's not a different method. It's just an objective measure. But I didn't catch his specific words with the way that he answered that question. Are you a certified firearms tool mark examiner? Yes, he is. With whom? With AFTI. Would individual marks be lighter or darker based on how hard the gun was cycled? He says hard cycling will change both the force and the angle of the tool marks, which is interesting. We didn't hear that from Ms. Oberg. So the harder you do it, it will actually change. That kind of goes to that repeatability and replicability factor. Ms. Luttrell said, and it's correct that more forceful racking can create more pronounced marks. And he said for the extractor, yes. For the ejector, it is more about the speed at which the gun is racked. Did you look at the subclass marks of the cartridge? Now, this was an interesting question, and the following question as well. I'm not necessarily sure that he entirely understood exactly what these questions were getting at. Subclass marks of the cartridge, right? The cartridge itself is a manufactured item. And so the cartridge itself is going to have, subclass marks characteristics between the different cartridges, such as, for example, the 2 Winchester bullets that were sought to be compared. So he says it is possible for a cartridge to have subclass marks. There's a 2016 article specifically looking at Winchester rounds and subclass marks. He then goes and points out that there is like one of the photos is of the extractor rim, and they can't tell if that is a subclass mark or an extractor mark. He says it could be better documented, or you could use a comparison microscope, but the photograph could be just as good as using the microscope. What is the relevance of cartridges having similar subclass characteristics? He says it depends if we're talking about cycling marks or manufacturing marks. This case, I think he's talking about the same cartridge because it was cycled multiple times. Having the marks in like the same marks but in different areas. Are the sequential serial numbers of guns made in the same lot? He says you can't really say that because the lots can all just be dumped in the same bin for purposes of assembly, and so it's generally understood that sequential serial numbers do not necessarily mean that the gun is sequentially produced. Are you aware Ms. Oberg's findings were reviewed by a second analyst and their findings agree with her? He said yes. Then he talks about the review process. So there can be non-blinded review, which is the most biased, where it's like, here, I say this is a match. Would you take a look at it and double check it? That has the most opportunity to introduce bias into the review process. There's a semi-blind where there's minimal communication, but there is still like the markings on the cartridges are not removed and the groupings are still, where they are. So, what was compared. It basically shows how the comparison was done in this case. And then there is a fully blind review where all of the markings will be reviewed. Everything, is ungrouped, and it just removes all signs of the process that was performed. And that will be the least biased of all of these review methods. He says that file review can be part of that process. So in this particular case, he doesn't know that the verifier did not know the result. There was no testimony that there was testimony that there was no direct conversation, but no documentation as far as whether the markings were removed and the groupings and so forth. He says the policy also provides context because verification is required for all identifications. For others, verification is optional. So it would kind of create a presumption if I'm doing a verification, it's probably a match. Mr. Luttrell said, didn't she testify that she had all of hers verified in 2021, like all of hers, whether they matched or not? And he says, that's not my recollection. She said that the lab was moving in that direction and she supported it. But that said, he was not here for her testimony and he does not know that particular context. He's then asked if he knew who the reviewer was. Yes, it's Mark Kiesler, knows him as being the supervisor of the Indiana State Police Lab and a former president of AFTI. Are you aware the ejector of Mr. Allen's gun had a recessed portion that caused individual marks? Well, he says, generally, any ejector has a recess. That's the way that it works. It's got a recessed portion, and that's what it uses to like hook the cartridge. And so the question that exists, because what is not documented, is whether there are individual marks. So the fact that it has a recessed portion, it seems unremarkable. It's whether there are individual marks on the ejector that are important for purposes of comparison. So when she saw subclass characteristics markings for the ejector, she documented those, but she did not do that for other tools. There's no documentation for any of that. Asked if it's normal practice not to generate a report. He says probably greater than 50% of the time, yes. It's more likely if he does do an actual comparison, just because of the need to, document that particular process. And yeah, like I just said, it's pretty consistent with, at least with your working with the defense, you're probably not going to be asked to produce a report. What are the chances that the cartridge at the scene would have the same subclass characteristics as the cartridge at the lab? This is going back to that whole idea of the cartridge having their own characteristics. That's how I understood this question. I don't think he understood this question that way. But anyway, he says when a firearm is making a firearm, they will make a certain amount of stock. Most of those will generally start out in the same area, so the same geographic area. And that means initially, like the Sig Sauers that you find in Indiana are more likely to share characteristics than if you're trying to compare a gun in Indiana with a gun in Florida. So that was interesting. I thought that kind of made some sense as far as, because it just goes to the distribution, like everything gets shipped in it's made in the factory. It all goes into a box, and that box then gets shipped to a certain location. So then it will separate out from that location. And it would take time, for this gun to like drift and transfer all the way down to this other place. So it made sense. I don't think it exactly answered their question, but it might give them the information that they would need to be able to think to themselves, yeah, okay, a subclass characteristic on a cartridge in Indiana, be more likely to match another cartridge in Indiana than another cartridge from somewhere else. We had our lunch break at this point, and during the lunch, things were relatively smoother this time. My amazing line sitter showed up apparently early in the morning and was there to hold my lunch spot, so I didn't have to risk losing my spot after lunch. As a result of that, I was first in line. And we were then told, we were given some new news for tomorrow because, the chaos hasn't been adequate. It hasn't been enough. There needs to be more. And so we are informed for the first time that because of the election, we will not be allowed to line up outside tomorrow until 7:00 a.m. Wouldn't entertain any questions. Basically said you're not going to be allowed to put your chairs out on the ramp. Lana tried to ask, what about a person? He gets mad. No. I said no lining up. Not taking any questions. So that's our orders now. We can't line up until 7 a.m. because of the election. The election that probably has, I don't know, some results coming in. I don't know. I'm told that the reason for this is because they are counting the ballots there in the courthouse. And so it just has to do with security in case they have to do a recount or something like that. But 7 a.m. and we can't line up. This was always going to be a problem. What has ultimately happened is that after court today, people just started lining up on the sidewalk out front. Okay, if we can't be where we normally are, we'll just go to the sidewalk. And so the line kind of just reformed in a new location. I have no idea if that is going to be respected or not. Come 7 a.m. tomorrow morning. I think it will be. Somebody did apparently go clarify with the deputy that this would be okay for the line to be formed out there on the sidewalk. But the deputies themselves have not really gotten involved at all about like the legitimacy of the line or the process or anything like that. They just kind of do things their own way and they will make their own rules, but not really for the line as a whole. So maybe some chaos tomorrow, just giving you the heads up. Fingers crossed it's going to be okay because calmer minds saw the wisdom of just going ahead and getting organized with it now like we have been, but really not a lot of guarantees. So then there was a discussion after lunch about just redacted versus unredacted copies of one of the defense exhibits, which I believe is the one that was the letter that Rick had written to the judge that Dr. Wolcott yesterday had relied on as one of the handwriting samples to show here's his handwriting before he spent all this time in solitary. Then he wrote this confession to the warden, and here's how his handwriting is different. They were required to redact that letter. Probably there are things in it that Mr. Allen said about being innocent or whatever, not having his attorney appointed yet. Maybe they didn't want the jury to see that stuff. So they were required to redact it, and that got dealt with. And they would then publish that to the jury. McClelland also wanted permission to have an exception to the witness exclusion rule for the next expert. He wanted Sergeants Cecil and Bunner to be able to sit in. So as soon as I heard that, I knew we're getting cell phone forensics. This is what I've been waiting for. I have been expecting this to be like the conclusion of the case because the defense has really emphasized hard data, hard science, things that can't be faked, things that aren't so subjective. And really, that's all we got in this case that we can kind of point to as being hard data is the cell phones. And they've made a very big point of that, like displaying the cell phones. These don't lie. The data doesn't lie. So because of this, I am starting to anticipate, well, we might be really close to the end of the defense case. We might be really close to the end because typically you want to end on something strong, primacy and recency. People tend to remember the first thing they hear and the last thing they hear. The stuff in the middle just becomes a bit of a blur. So you want to start with something strong and you want to finish with something strong. And they've been hammering on this hard data. They've made so many commitments. They have laid up all these little traps about the phone data and the state's reliance on it and what they knew from it and so forth. That I'm thinking this might be about it. This might be about it. So I'll tell you how it went. We get Stacey Eldridge. Eldridge is the name of the expert. She has both bachelor's and master's in computer information management. She was previously with the FBI as a computer examiner and a senior forensic examiner. She has taken all kinds of classes related to computer, mobile phone, tablet forensics through that process, and she's taken over 110 classes since then. Her CV is introduced, and Mr. McClelland wants to interject to inquire about a section in where she discusses her work as an expert witness. Back in 2011, there's a case entry that is not complete, and she says, yes, I don't have that information. She doesn't have the full name of the case or the citation, just recalls that she testified and presumably what she testified about. She spent almost 10 years at the FBI. She was in the CART, which is the Computer Analysis Response Team, as a forensic examiner. And that's just the group of people in the FBI that are responsible for gathering, preserving, and examining digital evidence. And that can be from anything that can store data, anything from typical tablet, cell phone, to a smartwatch, a DVR, or even sometimes a gaming station. She has worked as a trainer of other agents. She holds multiple certifications. She had a certification for Celebrite, but she let it lapse because she no longer uses it. Her tool of choice is Axiom, and she is certified in that. She does digital forensics consulting, and she is an adjunct professor at 2 universities. 3 times she has testified for the government when she was in the FBI. Most recently, she testified for the defense back in August of this year. All of them are concerning cell phone digital forensics. So she agreed that local agencies would often work with the FBI to do analysis, and this was a service that would be provided to agencies such as the Indiana State Police by the FBI. Yeah. They're willing to do it if you're willing to hand over your extraction. Her company is Silicon Prairie Cyber Services. She was contracted by the defendant to review and perform services on an extraction. Her normal rate is $400 an hour. However, in this case, she has reduced that to $300 an hour. And as far as her comparability of her rate, she says she is right about in the middle of what's normal. Some people are more, some people are less. She spent about 65 hours doing her examination, and then she spent about 15 hours preparing for her testimony. And so for her work, she reviewed the cell phone extraction from Libby's phone that was the detailed one from October of 2017 that was done by Sergeant Bunner. She also reviewed their Celebrite reports, a couple of their of other reports that were done from other software types, their written reports. There were appendices with Cecil's, and she reviewed those as well. She also reviewed Sergeant Cecil's deposition. So starting with what kind of information is on an iPhone, she breaks it down. There's just all the normal things that are the user-oriented things that you expect, the videos, text, calls, apps, and things like that. There's also the operating system on the phone, which is the part that makes the phone work. And through the operating system, it has to log and track information about the activities of the person that's using the phone. So when she's doing an examination, it is complex. It's way more than just looking at the text, reading the text. She describes it as looking underneath the hood and everything that's going on underneath. And she uses forensic software to assist her with that. There's a lot of different types that are used. She says she couldn't even name them all. Celebrite is the one that is commonly used to extract. And then to review, she in particular uses Axiom. There's also some other ones that she doesn't use. In addition to Axiom, she uses two types of database software, including the database browser as SQLite, is how she described it. We'd heard it in Karen Reed as SQLite, and the forensic browser SQLite. Anyway. As soon as I heard that, I thought, does that mean there's deleted stuff? Is there deleted stuff? We didn't find any deleted stuff. Sorry. Not what that was about. So basically, different softwares present the same information in different formats. It just organizes it differently. So which one you use is largely a matter of what your preferences are. It's just a product of the free market offering people different ways of doing the same thing. So with the extraction, they try to get all of the data off of the phone, and it's basically making a copy to do the examination. The reason why you do that is because if you get on the phone and do things like Sergeant Bunner did, then you can change things on the phone. You can make other things disappear. In this case, she did not perform her own extraction. Celebrite, she acknowledges as being hugely popular in law enforcement as a tool, an examination tool. There are different kinds of extractions on different phones. And so with the iPhone, there is the full file system. She says that's the one we want as examiners because it gives us all of the user files and all of the operating systems. The one below that is the advanced logical that gives some user files and some of the system, but it does not give the database files or the logs. And then the logical extraction is just the bare bones extraction. So the best practice, according to her, is to always try to get a full file system extraction off the phone first. She says sometimes you have to try it a few times because since phones are like constantly changing, you might try it once and it doesn't work, try it twice and it doesn't work, and the third time you try it, it will work. So you have to try it a few times and document everything that you did to be able to get that full file extraction. So on February 15th of 2017, Sergeant Bunner did a logical extraction, and that provided some basic user stuff. Using the Celebrite version that was listed on his report, they had the capability to do a full system extraction on Libby's particular phone with Libby's particular operating system using that particular version of Celebrite. and that the only exception to that was a encrypted backup that would go through iTunes. However, in this case, a full file system extraction was not done until October 2017, and that this caused issues. Main one, because the phone shut on and off several times. Every time you power down, you lose some temporary files. So as the phone ages, files will drop off due to the age, like they will be programmed to only be retained for a certain number of days. And then because of this, they lost some data that could have been helpful in telling the story of the phone. Example of that is the current power log. It shows exactly when the phone was shut off, but the next time you power the phone off, you lose the data from the previous time. So there's also other info that was lost, such as whether the phone had been placed into airplane mode. So some of that data is there from the October 2017 extraction, but the last time of the shutoff on February 13th is missing. It is not there. So when she examined the data, the extraction, her priorities were to figure out, one, what's going on with the Apple Health data, and two, what's the explanation for the phone suddenly receiving texts at 4:33 a.m. on February the 14th? To do this, she downloaded the Knowledge C database, another stuff we heard a lot about in Karen Reed. So this is the database that tracks a lot of what you're doing on the phone, things that are happening to the phone, like is the screen on or off, what's the battery level, what is the app usage. And so she says it's very insightful about what is happening on the phone. We're proffered Exhibit TTT, a thumb drive that is the Knowledge C database for the phone. Mr. McLellan says, I've never been shown it before today. I don't know what's on it. She also examined the timeline that was Defense Exhibit D that First Sergeant Cecil had prepared, and also his October 18th of 2024 report, which was Exhibit 227. We have a brief sidebar that the judge calls at this point. No idea what this is about, but when they get back, Mr. McLellan says they had a chance to look at the TTT and there's no objection to it. So they go ahead and display it on the screen. There is a little interaction between Ms. Auger and Mr. McLellan that illustrated to me that she does not like him one bit, where they're trying to get the screen positioned into the right area. And she's saying, I don't want to touch your very expensive thing here. And Mr. McLellan says, you've been touching it the whole trial. Now you don't want to. And she says, actually, I haven't. He's trying to be like light and funny and frivolous. And she's very serious. Actually, I haven't. So they display the Knowledge C database, and based on what was displayed, the meaningful information was on the right end of it looks like an Excel, appearance wise, it looks like an Excel type of spreadsheet. But so she's saying the important stuff is at the right end. So these are Z metadata areas that she focuses on. This is like shown to us what they are. If there is a lot of Z metadata, then the database viewer says blog or blob or something. And so what she does in that case is that she will change the view from the metadata view to the text view, and then she will create a new column where she places that information. As far as why they are all named Z metadata things, she says you would have to ask Apple. She has no idea why they chose to name it that way, but there's apparently lots of Z files on Apple devices. So we look at Cecil's timeline, says that generally there are some things that she agrees with and some things that she doesn't, and other things that she was able to analyze further. What she does not agree with is the date and time that iMessages FaceTime phone calls and voicemails were delivered between February the 13th and February the 14th. She does not agree with his analysis on that respect. She acknowledges there was a time when Libby's phone did not connect kind of throughout the course of the afternoon on February 13th. It was losing, kind of going in and out of signal, and that the last time of connection on February 13th was at 5:45 p.m. The next reconnection of the phone was the following day on February 14th at 4:33 a.m. So she says it's customary to review records from cell phone providers, and she did so in this case. So she received and reviewed information regarding pings and location information that was logged by AT&T. So we have a new exhibit that's introduced. It's QQQ. This is a log from AT&T that is referred to as the historical location precision information for the phone. Mr. McLeland wants to ask foundational questions. Is this the entire log? I looked at more records. Is there more records than this? She says, I looked at more than this. I got trained to review this document, and the FBI is questioning her qualifications. Do you even know how to read this thing? I got trained to review it in the FBI probably around 2009. Any training since then? Well, not formal, but I go to the seminars and things like that and keep up with the information trends. Has she ever had network training in network engineering or capability in Carroll County in 2017? Like the series of questions about network engineering. And she says no. And does she work for AT&T? And she says no. So the state objects on the grounds that he thinks it's not a complete log. However, he then asked, did we stipulate to this? And Ms. Auger said, yeah, you did. So he says, and we're not raising foundational issues with it then, but it's not complete, and I'm not sure that she's qualified to talk about it. I noticed that during this examination, Mr. McLeland is not in his loud and confident voice today. Normally, he is loud and he projects and he's out there, and this is the first time he's really subdued. He's really subdued, and it makes me wonder, does he know what's coming? Is there something bad coming? Does he know? I don't know. So Ms. Auger follows up and asks, has the form of the record that is, this historical location data thing, has that changed at all since training? And she says, no, it's the same, and that the trainings present specifically on things like this. And asked if there's anything specific to Carroll County that would affect the report. She says, not to my knowledge. And then as far as the incompleteness, Ms. Auger says, she tells the court, just look, this is one of hundreds of pages. I'm attempting to keep things simple for the jury and not overwhelm them. This is the page that contains the pertinent time period. Under the rule of completeness, of course, if Mr. Leland wants to admit the rest of it, he can. And that then led to this document being admitted over the state's objection. So she asked, what did the location information tell us about Libby's cell and about the connection to the tower between 5:44 and 4:33? So it showed the date and time of the last connection and the location where it was connecting. And that location data is provided in longitude and latitude. To get the time of the connections, the times in the report are set out in GMT, Greenwich Mean Time. It says it's interchangeable with the UTC. On the iPhone, times can be stored in a whole wild array of formats. Sometimes it will be things like the number of seconds from January 1st of 1970. But when you do an exam, you do them all in UTC so that everybody's on the same page. So they went through the line items and just established the last connection, date and time, February 14th, 9:33 GMT is the same as 4:33 a.m. local time. The connection before that was at February 13th, 2017 at 22:44 GMT, which makes it 5:44 p.m. We already know this stuff. And I'm like, what about this latitude and longitude? I want location. I want location information. but I'm not sure I got anything that's usable. At least if they did, they didn't tell me. If it's not called out, then it must not be exceptional information. So I'm not entirely sure why we're going through this. She says there is also data on the phone that correlated with the information from the provider. And yes, that there were numerous things on the phone that showed at February 13th at 5:44, a call came in. It showed disconnected. And then it logged because the phone also logged when apps use data. There was none logged between those two between the 5:45 until February 14th at 4:33 a.m. So these were all things that correlated with the information from the provider. So on Cecil's timeline, it showed iMessages coming in between 5:44 and 4:33 the next day. She said that iMessages are Apple's proprietary short messages, and that they developed this because you used to have to pay for every text. I remember that. I remember when you had to pay for the texts. And so this was a way that you could go over data and use Wi-Fi instead to send your texts, and then you wouldn't have to pay for them. And so that still holds true today, that you can use Wi-Fi. The message will hit the Apple server. It will put the date and timestamp on it at the server, so from the date of the sending. And that is not evidence that the phone received the messages. She says there is evidence the phone did not receive some of those messages throughout the day, and that they were not delivered between 5:44 and 4:33. They were delivered sometime after that. So then we saw some more lines that talked about calls being backgrounded, and then a voicemail. She said, as far as the 450 to 455 on this sheet that showed calls backgrounded, she couldn't find evidence of when missed calls were missed on the phones, but she was able to find when voicemails were left. And so there's a voicemail line that's time-stamped at 6 p.m. And she says there's numerous voicemails between 5:45 and 4:33, but they are not delivered to the phone until February the 17th. So not even the next day, like a few days later is when the voicemails show up. And that she got that from another log that is on the phone. She then describes a ping. It's a technical way to communicate whether there's anyone, are you there? Hello? Is anyone alive out there? Yeah, you my Titanic people. You know what that one is. Hello. That's the ping. That was sending out a ping. And so the phone then, if it receives the ping and it is in fact out there, it will send a response message back that says, yes, I'm here. So as far as the pings and the tower data goes, she says it shows AT&T is repeatedly trying to ping the phone after 5:45, but they can never successfully ping it again until 4:33 the next day. And that there's at least 3 data points showing the phone, no connectivity with the phone between the pings, the voicemails not being delivered, and the lack of data usage. The testimony skipped, but I'm going to go back. I'm going to not skip. I'll just wrap up this part. So in the 5:44 p.m. to the 4:33 a.m., she's asked, do you have any explanation for why a stationary phone would not connect? And she said she found no evidence on the phone to suggest what had happened. And so she can only conclude it was something external to the phone that caused it not to connect. And so the possibilities that she considered was that the phone had been moved, the signal had been blocked, or that potentially like metal, there's like some metal enclosure that can block cell signals. And she uses the example, when you get on the elevator, your calls will often drop. So then we move to talking about the Apple Health data. She says that only Apple knows exactly the secret sauce of what they're doing, but somehow it is measuring movement and vibrations of the phone in order to determine steps. So there have been studies on steps, the distance, the elevation. It's done by the Forensic Science Institute in The Hague, which she described as being a big deal. She says it logs it even if you don't set it up. The accuracy of it has been studied. There are things that can affect the accuracy. Generally, the steps are very accurate. The distance can be off anywhere from 30 to 40% in either direction, and that motion can affect its reliability as well. So Sergeant Cecil outlines the Apple Health data at page 8 of his report, and she says she generally agrees with that. She saw the same information when she looked at the extraction. So when asked if the phone can move without being recorded in Apple Health, she says if it's moving in a vehicle, the program, it can note the difference between moving in a vehicle and walking. And so asked if the iPhone 6X would log steps or movement if it was powered off, she said no. And she says when the phone was found, she understood that it was powered off. And so was there any activity that she found on the phone after 4:33 to suggest the phone was on? She says no, because there was no data logged. So Cecil's timeline was a general analysis of what is in Celebrite and Axiom. She then goes to line 348 of Sergeant Cecil's timeline. And this is entitled Knowledge C Audio Output Route on 2/13/17 at 5:45:45 start time. So this is at page 4 of the report, and he addresses it there. He says that his research is incomplete, or the research is incomplete, but it could mean any number of things depending on what's there. There are a variety, she explains, a variety of number codes that relate to certain activity relating to audio output. And so it could be things like a call is coming, there's a headphone plugged in, a speaker, could include Bluetooth information, stuff like that. She says the research is now complete in 2024. There are known numeric values for the codes that are shown in this line. And so, for example, one shows that is equivalent to a headphone. So what happened at 5:45:44? Read the audio output route contained in the Knowledge C database. She said there were several of those things that occurred that day. At February 13th at 10:32 p.m., a record was created, and the start date showed 5:45 p.m. The end date showed at 10:32 p.m. The numeric value that was logged was number 1, and that what that meant was that a headphone was being inserted, and that is what the phone was recording. There was additional data that confirmed that this would be wired headphones. It could also potentially be an auxiliary cord. And so what she did is she viewed the text information, where she had mentioned you get the blob reading sometime from the metadata, you turn that into text. So when she read that, she could see references in the text to headphone and wired headphone. So the code told her that that is what they were dealing with. We then had a demo with an iPhone and a pair of wired headphones, and plugging it in and demonstrating this is a very solid connection, because you can hang it upside down by the cord and the connection will stay in place. So that's not, I think what they're getting at is it's not, something that is likely to be an inadvertent, something that happens. So interpreting what this all means, the audio start input means that somebody took a headphone jack and inserted it into the hole at the bottom of the phone at 5:45 p.m. on February the 13th. Then at 10:32 p.m. on February 13th, someone removed the cable. Definitely not consistent with the state's theory of the case. Human hands on the phone. That's what Mr. Baldwin said in his opening statement. There would be data showing that human hands use the phone. Wired headphones don't plug themselves in and out of phones. Somebody did that at the time when the phone is supposed to be under Abby. Asked if there is any explanation that does not involve human interaction, she says there's none. And the effect of putting the jack into the plug into the jack is that you would stop the sound coming out of the phone. And Ms. Auger asked almost as if he wanted to hide it. There was an objection to this as being leading, and that was withdrawn. But Ms. Eldridge noticed that before there is like milliseconds before the cable is inserted, there is an incoming phone call. So kind of like call comes in, you shut it up real fast. That looks like what the defense is theorizing here, that the data shows. The Apple Health data, she agreed that it shows that flights were climbed at 2:32 p.m., that each one was approximately 10 feet. And so that's not really consistent with the state's theory either. The state's theory was that the flights were climbed sometime within a broad range of times that ended, like a 15, 10-minute period, something like that ended at 2:32. This expert seems to think that the flights were climbed at 2:32. And so if that is true, then that is probably not going to be consistent with the state's theory of the case either. Because at this point, their theory of the case is that the reason why the phone stopped moving at 2:32 is because that's when Mr. Allen killed the girls. That's the state's theory. But they were across the river in a low area in the floodplain, nowhere near, two flights of stairs. And it would have taken them quite a bit of time to get there from, the last highest point they would have been on at the high bridge at 2:13 when they're being abducted. So that was what we got. That was what we got from the defense. That was the piece of information that's been hiding in the cell phone data that we've been hearing about. We've been kind of waiting for. I will confess, it's not everything I would have hoped for. I would have loved location data. I would have loved something that actually could confirm the movement of the phone. But as it goes, this is something that can't be explained. If their interpretation of it is correct, this is something that can't be explained as just a thing that happened. Well, the state is going to try to go there. They're going to raise some questions about that. So let's go ahead and go to the cross. Mr. McClelland also, he does pick up speed throughout the course of his cross, his tone. He picks up his tone and his upbeatness. So I think he feels good about where he's going with it. So first asked about her training, that, back in the FBI is when she was primarily trained. Recently, she's received more training in the manner in which extraction should be conducted to get the most data off of them. It's just an ongoing thing, and the different states that the phone can be in. She listed a training from February 2023, said there would have been high-level topics addressed there. Her most current training is in April of this year, and then another one in October of this year that is not on her CV yet. And both of those are trainings in how to process extracted data appropriately, which is what Mr. McClelland was asking about. So before that, the last training that she had Formal training was back in 2009. So none between 2009 and 2024, none that she can recall. In 2007 and 2009, her testimony both involved computers. In 2011, the case she testified in involved both computers and cell phones. She can't remember the name of the case, but she has tried to find it. In July 2024, the case she testified in concerned specifically an iPhone and a video, but not just like examining the video. It was about how did the video get there. So it involved this same type of database examination. Asked if this was the first time she is testifying about the Knowledge C database, she says no. Earlier testimony in July was about cell phone analysis. So her primary focus was the extraction from October of 2017. The AT&T records gave the rough location of the bodies and the cell phones. Other than that, that there was another female, with information, I think, on the phone. She was aware that the phone was found under Abby's body. She did not examine. What did I write here? I can't quite read my word here. She didn't examine everything that was gathered between 2017 and 2024. And she also, Cecil. She didn't examine everything that Cecil had gathered between 2017 and 2024. And she specifically had narrowed the scope to the Apple Health data. So to figure out what happened at 4:33, she worked backwards to evaluate what had happened on the phone that day. So she went back to about 10:30 that morning on February 13th when the phone was on low power mode. She says she does not agree with everything that he said that day. She agrees there's no evidence of manipulation of the timestamp or the GPS on the video, the Bridge Guy video. But also says she did not examine it that closely concerning, she's asked about noticing that the GPS data changed like 4 minutes later. She says she did not examine it that closely. She did see some of the same info in Axiom about the Apple Health data. So she agrees that the data is correct, but she can't speak to whether she agrees with any opinions Mr. Cecil may have documented. But she does agree with the number of steps and the numbers. The last reported movement was 2:32 p.m. in Apple Health. She says there are more steps and in database info in other places that can potentially go after that. That got my interest. I'm just assuming that there's nothing there or we would have heard about it on the direct. But I don't know. She agreed that the phone did not log any movement in the Apple Health data between 5:44 p.m. and 4:33 a.m. She explains that this is because the phone is looking for vigorous motion and activity. It has to bounce up and down to have some detectable movement. And so it may not register if it's moving in a vehicle. If it is, it's possible, however, if it's being moved in a vehicle that it could log data. So it may, but it may not. It's not necessarily like a definitive thing. So between 2:32 and 5:45, there was no evidence she could find that the phone was turned off, but we know that the power logs were lost because of that last, that handling that Bunner put it through. 5:45 was the last known time of service, and before that, it had been in and out of service. Asked if she agreed that phones in a poor service area can go in and out if the phone is not moving. She agreed with that. Said she does not know the service in this particular area of the crime scene. She didn't study the topography. She did not consult with a network engineer. I made a little star by this because these are good questions, but they're questions that should be directed to the state. Did the state do any of these things? because you're the ones that had the phone for 7.5 years and the responsibility of solving the crime and to helping us get a picture of what happened with the phone. And so answering the question of why the phone went dark seems like a pretty important piece of the puzzle. And so the fact that, according to the prior testimony, it seems they haven't done that. They said they never investigated the towers. That was a jury question. They never did that. This stood out to me because, yeah, sure, these seem like good things that should be done. Why did not you, the state, do these things? So she's asked if it was reasonable to believe that the phone went in and out of service while it was stationary on February the 13th to February the 14th. We acknowledge that it got calls and messages until 5:44 p.m., that there was no Apple Health data registered showing movement after the 2:32 time. So we just know that it went in and out of service. It did not receive calls and voicemails. He said, didn't it continue to receive FaceTime calls? She said it does not continue to receive FaceTime calls after 5:45 a.m. So after 4:33 a.m., it got the new messages that could be based on bouncing in and out of service. She says it's possible. She did not have factual information to be able to judge whether the phone had been moved, that there was no information in the Apple Health or the Knowledge C data that would show movement. Mr. McClelland is then asking, wouldn't you have to move the phone to be able to put in the headphones? And she says, well, there is a difference between picking up a phone and moving across the room with the phone. So plugging in the headphones could register an Apple Health data. She didn't test that. She said asked if one possible reason the messages came in at 4:33 is because the phone was moved. She said she had no specific evidence, but simply was testifying to what was possible. It could also be a signal blocker, which is a thing that keeps the phone from receiving signal. I'm talking about a Faraday box or a Faraday bag, or metal from the building. The phone would have to be moved to be placed into, some type of building. Asked if she agreed that the most likely possibility is that the phone is going in and out of service. She says she doesn't have the data to say. There's an objection to this as speculative. And Mr. McClelland, does a speech to the jury after he's accusing others of making speeches to the jury. It was Mr. Luttrell that accused Mr. Rosie of making speeches to the jury. Mr. McClelland now makes a speech to the jury. I'm showing how unrealistic her possibilities are. And so the objection is overruled. She says the fact, and so she answers she doesn't have the data to say. So from 2:32 to 5:35, it's in and out of service. And then after that, it's out for many hours solid. And there's no Apple Health data showing movement. That's kind of the bottom line from the state. They ignored this microphone thing altogether at this point. So Ms. Auger redirects. She asks about her knowledge of working with the Knowledge C database. She says it's one of the main databases that she works with. She also teaches about it. She agreed. She reviewed all the pertinent information she thought she needed, given the number of hours that she had. Once again, if money is no object, you can do everything. But when you have a budget and a court that is involved in deciding what you get to do, then you have to prioritize what you look at and what you don't. And as far as information that she would have liked to have that she didn't, she says, well, if I had a full file system analysis from February 2017, I could have recovered some of that info. I could have, received it and had it available. Asked about the cell tower service questions, she's asked, is there a service that law enforcement officers can provide to show service? Mr. McClelland objects at this point. He wants to ask foundational questions. Is she familiar with the Carroll County Sheriff's Office or the ISP or the resources that were available in 2017 or to the FBI? No, she's not familiar with all these things in 2017. So he objects to speculation, and that's sustained. So Ms. Auger simply comes back and says, what's a drive study? And she says, it's where you drive around and get data from tower strength, that the FBI CAST team did it. And there was a document that was leaked onto the internet in 2018 that was showing all of that. And it was theoretically available to the FBI in 2017, this drive test data. Asked about having to move the phone to plug in a cable. If Abby's body was not on top of the phone, would you need to move it to plug in a cable? And the answer is no. And then the same thing at 10:32. The body is not on top of it. The phone would not to be moved at all, or it would not need to be moved enough to log a step. And if the phone is in the vehicle, it doesn't necessarily log movement. If at 4:33 the phone is somewhere else and it powers down, it would not log movement after that. So these are just some of the different explanations for how the phone could have been where it was and not logged movement, not had signal connection, and yet still had this headphone plugged in, headphone plugged out, little bit of data. Mr. McLeland then recrosses, if you're not in a vehicle, but it's carried, the phone is not in a vehicle, but it's carried, would it log data? And she's like, well, it depends on where it's being carried. If you're carried in your hand, yes, it would log movement. And he's like, well, then a bump in the car. And she says, one bump in a car is probably not enough to log some steps. From the research that she read, it takes a little bit for it to realize that the phone is in motion. So it's not just like a one. It's going to require some type of repetition. So if somebody moved the body and plugged the phones in and out, would it log the movement in Apple Health? This is a bizarre question. She says she doesn't know. Is this really a theory? I mean, talk about the state changing their theory. Is this going to be a new theory now? That somebody went and plugged a headphone in and out underneath the bodies? For why? I don't know, but it doesn't seem to have mattered. I did notice after this testimony that one of the jurors is just kind of gazing long out at the audience. Two of them are talking and laughing to each other. They're having a joke, and one of them is yawning. We had a number of jury questions here. Did you ever write your own report or timeline? She said no, because of her limited time. Could any of the knowledge in the database information be related to her iPad? And that was a good question, I thought. She said if there is syncing, it would log that. And the follow-up question, would the iPad have a separate Knowledge C database? And she says, yes, it's got its own Knowledge C database. And so what is synced is typically things like preferences and data, not the Knowledge C database. So in other words, Knowledge C would not like port from activity on the iPhone somehow into the phone. That I think was a very good question, because that's a good thought, right? If these phones are synced up, if I plug something into the iPad, is that going to show up on the phone? And the answer to that appears to be no. They have separate Knowledge C databases. Question, would water or moisture affect movement data? She does not know. Very interesting question. Would water affect the port for the headphones? She says she has no knowledge that it would. Water damage generally can affect what can be plugged in and work, but it would not cause it to suddenly log a headphone. Could you tell from the data if the phone was on silent or vibrate? She says she did not look. It's an unfortunate answer, but the reality is she is limited on her time. It's just that it would be nice to express that in a way that is more, I didn't look because. Is there a device that could be inserted into the headphone jack to disable the cell signal? She said she looked into that. She did some research and she was not able to identify any such thing. Would you be able to review Richard Allen's historical precise location data from Ting? And she said, you certainly could if that is data that that company maintains, if they keep it. Mr. McLeland follows up, would you need the 2017 phone to get that? She says, no. Next jury question, how common was Ting as a provider in 2017? She does not know. Asked if what are the other ways that the phone can register movement besides Apple Health? She said there are other apps that will do it, and she used WhatsApp as an example. And then the follow-up question, did Abby's phone have those tools? And she says this time, I didn't look at anything specifically besides Apple Health. So we don't know if Abby had WhatsApp. That's just the one example she gave. She said there's, a variety of apps that will log movement. I didn't know that WhatsApp did. I kind of don't like that. I don't necessarily love that. I mean, it is what it is. I should, give up having any sort of idea that like the phone, there's any privacy when you have a phone in your pocket. We take a recess at this point, and during the recess, the judge lectures the courtroom that security has advised her that folks are talking in the gallery. I've asked you repeatedly not to talk. Don't talk. If you talk, court staff will tap you on the shoulder and escort you out, and you won't be allowed to return. Don't talk in court. So Ms. Auger then called Christopher Cecil back to the stand. First Sergeant Christopher Cecil from the ISP talked about his timeline, pointed out the note on there that's regarding the audio output start. He concedes he doesn't know what that is, and that is he able to discuss the reasons why a call would not connect to the tower? And he says no, he doesn't have that education. That was all she had for him. Mr. McLeland said, what does he understand this data point to be? And he says, well, according to what she said, it has to do with a headphone being inserted into Libby's iPhone. He wasn't able to research that at the time of the report. The most recent research then was in 2022. And so at that time, he couldn't definitively say it's caused by headphones being plugged in. It sounds like they're trying to, they're trying to save him from the fact that he knew that it was there, like he identified it. It's there on his timeline. But he, kind of was saying, well, we don't really know what this is. So he's saying, well, just at the time, I couldn't have told. And so that's why I couldn't definitively say, but well, could you say maybe? Could you say possibly? He didn't say that. We've heard a lot of possiblies from the state about their theories. Then asked if he had heard a question about water damage. He had. And did he have a chance to research that over the break? Why, yes, he did. How did he do that? Well, he did a Google search. Ms. Auger objects to this on hearsay grounds. It's clearly hearsay. What random information is on Google in Google search results is hearsay. Mr. McLeland, or he can rely on it. It's and so she overrules it. Google search. And so in his Google search, he learned that water or dirt in the socket could cause the phone to register a headphone in the socket. Didn't say anything about how water or dirt in the socket could cause the phone to log a headphone in the socket in the Knowledge C database. So Ms. Auger gets up after this and she's pretty heated. So she asked, what site? He said, I Googled it. There's multiple returns. Which ones? She's like, well, there are troubleshooting sites from Apple and from Walla. And she says, you didn't research this at the time? No. You didn't look into the accessory out function in the search, in his search? No. Do you normally do your research in Google? No. Do you normally look at peer-reviewed research? Yes. And you didn't look at any of this before? No. You'd agree there's a lot out there on the internet that isn't true? Yes. And that you generally prefer to rely on peer-reviewed research? Yes. Is there any other sign of water damage on the phone? I didn't look. Did anyone? I don't know. And for the last 7.5 years, it's been in the sole possession of law enforcement. Yes, it has. And law enforcement would be able to look for that. Do you know if there was dirt on the phone when it was found? He does not know. You've had 7.5 years to determine this information? Yes. And you're coming here after doing a Google search? Yes. It was a very fiery cross. Auger was pissed. You're going to come out here with a Google search? For real? You ignored this? You pretended like you didn't know what it was with your little special footnote? The research wasn't complete, so you didn't know what it was? And now you're going to come in that your research is a Google search? Mr. McLeland just recrosses. The phone was found under a shoe, yes, and on the ground in the woods, yes. Mm-hmm. I don't know that this helps him. I could see, like, okay, I can imagine a scenario. Let's say this is correct. Let's say if there's like dirt or water that gets into the headphone jack, that could cause the Knowledge C database to register a headphone being plugged in. What would cause the registration for the headphone to be logged out? Well, we don't know. In that situation, maybe the dirt could fall out. Maybe the water could evaporate or drain. Conditions being under a body are not going to be conducive for either of those things to happen. Right? Let's I can imagine a scenario. Somebody tosses the phone, turn it on, toss it, and then the body is on top of it. In the course of tossing it, it gets dirt in it. How's the dirt going to come out 5 hours later? Let's say it's water. The state wants to have this theory that they were forced to cross the river, the lake, at 2:32, or right before. At 2:32, they are killed, and the phone is under them the entire time. So, okay, so the actual submersion of the phone, if there was submersion of the phone, that didn't affect the phone's operation because the phone continued to ping and continue to have activity and continue to show movement. So that doesn't really seem to work with the timing. Maybe it's thrown and there is just moisture, and a droplet gets in there and it registers. It's trapped under a body. That's like on top of leaves and soil. This is going to be a humid environment. This is not going to be conducive to this phone, drying out. I appreciate this thought process. It's good. The problem is that when it's the state that has the burden of proof, you need more than just a maybe. You need more than just a maybe because of a Google search. I mean, this seems like a pretty compelling piece of information that they're just really not not prepared to be able to address. So, I mean, I guess they didn't know what was coming, but I mean, he had it in his report. He knew it was there. So it's just strange that this is all they were prepared for. A Google search in the hall during the recess has solved the answer of the cell phone. So then Ms. Auger called Lieutenant Brian Bunner. Basically, same questions. ISP, he worked on Libby's phone on February the 14th of 2017, as well as since then. He does not know what the audio output means in the log. And did you do any Google searches over the break? No. Good one. Good one. So that was, we went to sidebar after this. It was a little bit early, a little bit after 4 o'clock. So they have a fairly short sidebar. And I'm seeing conversations between the juries. Two of them turn and ask each other something. A couple of them are talking. A few of them are like talking and laughing. One of them checks the clock. One of them is having a conversation and like laughing quite hard. Don't know what about, obviously. But boy, a Google search. I know what I would be laughing about if I was sitting on that jury. Unbelievable. 7.5 years. It's not even the data that they're being confronted with for the defense theory. It's not even a surprise. They already knew about it. And they never bothered to deal with it. This is, theme. Sticking their head in the sand with the bad facts and just pretending they don't exist. You should have gotten out ahead of this. You really should have. If you'd ever spent a day as a defense lawyer, you'd know that. You'd be experienced at that. And you'd have thought this through before your recess. Now, it's possible that maybe there is an answer out there and it's not favorable. That no, having dirt or moisture or something like that in the headphone jack could cause problems with being able to connect a headphone, which is what the Ms. Eldridge said. It's not going to cause it to log a headphone in the database. So it's possible that that's out there, and there isn't anything. If they went and researched it, it would just be definitively this was a headphone. And so they had to remain ignorant until they could do a Google search at the break. I mean, I just don't even know. I don't know what to make of this. I don't know what to make of this. We were like lots of us joking about this after court. I mean, he's saying these are troubleshooting forums. Like, I've used those troubleshooting forums. You know what they tell you to Google? They tell you to go Google your problem, Ugh. A troubleshooting forum is not a forensic analysis. I mean, that's been the entire point of all of this. If you are on the internet trying to troubleshoot a problem with your headphones on the Apple website, you're a user. You're interacting with it at that level. You don't even have access to the Knowledge C database and this log and this information unless you're in the extraction business. So your inquiries aren't going to have anything to do with this specific question about how is the Knowledge C database going to perform under these conditions. This jury is smart. I know I can't be the only person that thought that. So after the sidebar, the court came back and announced that it was going to be the end of the day. They then had, so the jury was released. They then had a short sidebar after this again. It appears to me that they are talking about logistics as things are kind of wrapping up. What are we expecting in the next, day or so? so that we can get the timeline set, so that we know when we're going to need to be doing things like, well, for the state, bringing their rebuttal witnesses, assuming they're going to put on a rebuttal case, and I am assuming that they will. I think they're going to probably want to bring back Melissa Oberg, and it doesn't seem to be any need to bring back Cecil or Bunner. I mean, we already got that taken care of here. But the state just has this habit of wanting to have the last word, even if they're not telling us anything new. So they'll have rebuttal just to put on, repetitive information that we've already heard. It's the pounding the fist on the table. You don't have anything to add to it, so you're just pounding on the same thing that you already have. That's what they've been doing with their rebuttals, their redirects throughout the case. So I expect a rebuttal case that pretty much looks like that. But I wouldn't imagine it's anything extensive. Oberg is the main one I can think of that they might want to bring back and address some of those criticisms. But because just put her on the stand and ask her. He said you didn't document concerns about subclass characteristics on these two items, and she'd be like, yeah, because I didn't identify any. There wasn't any concern with them. Something like that. They'd still get into the problem though with the fact that he reviewed her work and looked at what she was identifying as individual characteristics and doesn't think you can make a match. So, I mean, she can pound on the table. You can't do that based on photos. And the jury will just decide who they believe. They'll decide who they believe. And, that witness for the defense, he's got impressive degrees. He held up extremely well under an extremely argumentative cross-examination. Not very effective, really not very effective. If the juror did in fact yell at the court, I mean, that's a sign. It's a pretty good sign. They're not really happy with how you are conducting this and how you're treating this guy. I really do. I on the one hand, I think if that did happen, if the juror had an outburst, like surely the judge would have said something. But then the other part of me is like, that's just not how she's been with the jury. She really sucks up to him, really sucks up to the jury. So maybe she would just let it go. I don't know. I mean, I could tell I myself am sitting here, going, good Lord, what is your problem? What's your problem? You don't have to do this like this. You can ask questions in a polite way. Once again, if you've ever been a defense attorney, you've had to learn how to cross-examine people without looking like an asshole. When you have to cross-examine like crime victims, children, yeah, you got to learn ways to make your points and to bring out the information that you're there to elicit, which is what cross-examination is for. Without being all sneery and rude and like, it's not necessary. The facts and the evidence should speak for themselves. So if you have it, you don't need to engage in these kind of tactics. So that was the conclusion of our day today. And we will wait to see what tomorrow brings as far as the line, chaos, the state of the country and the election. Who knows? I don't know. You guys have probably had updates that I haven't, but let's go ahead and take some time to go through your comments here. We started with some Andrea Burkhart memberships gifted by our Red Pen. Thank you so much for that. Appreciate that. Julie, can the defense not bring up the seating issue with the court? Well, they did go and bring it up with, I believe, Mr. Sheriff Lesenby, Toby Lesenby, former Sheriff Lesenby. And he kind of came in and sort of made press shuffle seats, and he was able to like get them one more. but that was like as far as they went. So I don't know if the judge is already involved in this or not. I don't know if they're just at the point where, they're not getting anything from the judge. So why bother asking? It's just expect that this is how it's going to be at this point. I really don't know. But I don't like it at all. It's a big problem. That the press is getting priority seating before the defense team is a big problem. Alicia Douglas, Andrea, do you know if there was a toxicology report done for Libby and Abby? If so, what drugs were looked at and what were the results? So we were told that toxicology was standard as part of the autopsy, but we never heard anything about any results. So it doesn't sound like there was anything that came back in the screen, or we would have heard about it. Mad World, consider subbing to @ExcitedUtterance, folks, please, or Gull will get you. Yes, by all means do. Our fabulous mod, ExcitedUtterance. She's been doing some great coverage of this case and many other cases, and she's just an all-around pretty awesome person. So go sub. Check that out. Clutch Case Files. Bridge Guy has always been a red herring. Libby didn't record her own abduction. The aux cord being plugged in and pings point to the evidence being planted. Who would do such a thing? Well, I don't know. I did think the implication of a signal blocker, I thought that was fairly interesting because, we know what some of the theories are about this case. And, we are certainly asking questions about why does law enforcement seem to be messing so much stuff up and not asking the questions you think they would be asking if they really wanted answers here. The whole thing with the green hanky that we talked about yesterday, the one thing they didn't test is the one thing that looked like it might maybe belong to the murderer. You got the hairs that don't match Abby and Libby, most likely to belong to a perpetrator. And you don't compare those to Richard Allen. You don't even ask the witnesses on the stand if the person that they saw, that they identified as Bridge Guy, is the guy sitting at the counsel table. Didn't look into the cell tower data, all this stuff. There's just so many questions that they didn't ask. It raises questions about why didn't you want the answers? And so that's why when I hear possible explanation is the phone is in a signal blocker. Well, gosh, who carries signal blockers around? That would be police officers. Yeah, they're little Faraday bags. Just putting that out there. Aria 7247, looks like Odinism takes part in sacrifices. Could that be why the child is bathed? The cult scenario answers so many more questions. Is Bridge Guy absolutely involved? I mean, I guess I don't know. I guess I don't know. I'm just not sure why Abby or why Libby would have filmed this little segment. The Abby running does seem like, okay, Abby is scared of, who's behind her on the bridge. And that's Bridge Guy. I don't know if Bridge Guy is alone. I don't know if Bridge Guy is one of the Odinists. I don't know. I think that the Odinism theory does have a lot of explanatory power. I still haven't had a chance to sit down and read those transcripts from the 3-day hearing. I'm hoping to do that once we get on to verdict watch. I actually have quite a few ideas of things that I'd like to do. I'm of course hoping it will be a fast not guilty, because I think that's what the case deserves at this point. But I'm not expecting that that's what it's going to be. So I do have some ideas of things that I'd like to look into, and we'll probably do some write-ups on my Substack, depending on how long the deliberation takes. And I'll do some, I have, even if we get a verdict quickly, I got some ideas of some follow-up things that I'd like to do as kind of like an epilogue to the case. But following up on those transcripts is one. Looking at some of these side stories that are connected with Delphi, like all these cases that you guys have brought to my attention, these ones involving Dr. Walla, these lawsuits against Dr. Walla. I was just brought to my attention a case where Judge Gold presided in a criminal case against a guy named Marcus Dansby, and apparently has exhibited a lot of the same kinds of tendencies, behaviors, problems, with how she treats the defense and so forth in that case as she has in this one. So I'd like to see what, if anything, I can find out about that. Very interested in the Flora fire. I want to learn more about the Flora fire. I don't know. I mean, I know that there's overlap in the investigators and stuff like that. I don't know if there's overlap in terms of like the theory of the crime, but I would like to know more. If you don't know about the Flora fire, this was an incident just a few months before Abby and Libby were murdered. It was a house fire, African-American family in the town of Flora, and where a mother lived with her 4 kids, and there's a house fire and all 4 of the girls are killed, and it's unsolved. They never got anywhere with it. So it's really, really very sad and tragic. And given what we've seen about the failings in this particular investigation, they seem to have a bad track record at being able to give answers for people dying. So that's something I'd like to look in a little bit more too. Anyway, the transcripts from that hearing will tell us a lot more, I'm sure, about what they know about Odinism and these Odinist practices, and how and why, the defense had experts that believed that that's consistent with what was found at this scene. So I would like to be able to answer that question more specifically. Alicia Douglas, do you know if February 13th or February 14th is a significant date in Odinism? I am told that February 13th is an important date. I don't remember the names of it, but it's a period, maybe like a week or a 2-week period or something like that. And the February 13th is the end of that period. So that is potentially significant in Odinism. Let's be realish. How many jurors did it appear contributed to the firearm questions? It was hard to say, but several, like 4 or 5. I mean, a lot of them. It was a lot of questions. Definitely more than 1 or 2. Barb Funk, anyone else see the YouTuber who bushwhacked his way from the cemetery down to the river under the bridge and found ATV trails, paths, and the road? A multitude of ways to get around and do evil things down there. That link has been sent to me. I haven't been able to watch it yet, but I am looking forward to that. I haven't been down in any of the like wooded areas where these events took place, but I am particularly interested in the south side of the bridge, and that was in part because it was that's going to be the hardest thing to access because it's private back there. You can't really go across the bridge anymore. I'm certainly not hopping the rail to get on that thing that's rotting and like, oh my God, the horror. No, no, not doing it. I mean, I guess you could wade across the bridge or wade across the creek, but I'm not real inclined to do that either. But yeah, I would love to see what it's like over there on the other side, because that's just been a big question for me from the beginning, is that if that's where Abby and Libby were supposedly taken down the hill by Richard Allen for purposes of having his way with him, then why would he abandon that location? I need to know. I need to have a better picture of what that location is actually like, because it's described to me as like there's a very steep embankment off the side of the road. And so if that's the case, then, that's going to block your visibility down to the bottom part of that embankment. So that's always been something that has, been on my mind since that testimony came out. And I would like to see that. And I think that's great that somebody did that, very helpful. Jim Green, thank you for your thoughtful coverage. Looking to the jury deliberations, 1, what are the possible lesser charges? I don't know that there are any lesser charges, and I don't know that he would propose any lesser charges. The thing with lesser charges, they have to be, there has to be an inference that they were, that only the lesser charge is committed to the exclusion of the greater. And typically, I don't know the specific standard for Indiana, but this is just fairly typical. And that's a difficult standard to meet in this particular case, because this is not a manslaughter situation. This is not an accident. This is not a, defeated self-defense type of situation. Like there's not really any way, given these injuries and everything, to pitch this as anything but an intentional killing. And an intentional killing is always going to be a murder. Now, could you take it down to second degree? Maybe. I mean, you could maybe argue under the state's own theory, they're saying that it wasn't premeditated. It wasn't even his intent. His intent was to have his way with them. And it was only after he got scared that on a sudden, impulse, he decided to go ahead and kill them. Well, if it's not premeditated murder, then maybe it's a second degree. So possibly that is a lesser. 2, if the jury is hung, do you think the state will, assuming no new material evidence, retry Richard Allen? Absolutely. Absolutely, I do. Yes, they will double down. They will dig in. They have gone too far already to be able to back down. And they've had a dress rehearsal. So now they will be able to regroup and re-strategize, figure out how to do it different the second time. And who knows, they might even, they scrounged up this van theory 2 months before trial. 2 months before trial is when they went to talk to Brad Weber to confirm what they had allegedly already known from Dr. Walla's notes. That he gave this van detail about seeing a van. And they sat on that, Sat on that until 2 months before trial. So they would have time to do more, more things like that. Yes, I absolutely think that they would retry him if the jury hangs. Arla 7247, if RA had just been in jail, not tortured, would the jury see him as human, possibly innocent? What's worse than murdering children? Maybe it happened this way for people to stop and look to see the truth. Evil can be blind. Yeah, I do think this is a good point, that if he's just some random schmo in jail, it doesn't have the same, it just doesn't have the same. I mean, it's a compelling part of the story. There's no way around it. The question, though, is if he's just in jail, is he going to confess without these conditions? That's part of the piece of the story is how beneficial it was to them from an ends justify the means standpoint to do what they did to him, because they got the evidence they didn't have. And Lieutenant Holman told him, I'm going to get the evidence. Told him in that interrogation, I'm going to get it. Rick Allen said, there's nothing you can do to me to get me to say something I didn't do. And they took it as a dare. That's what I saw from this case. So without that, it's a different case without that. Without that, it's a case that's going to trial, if it's going to trial at all, on eyewitness identifications that don't match, the descriptions that don't match, the wrong car being at the lot. We probably still have the fuzzy Hoosier Harvest Store video. We have Rick Allen saying he was on the bridge that day at a whole variety of different times. And then we have the bullet, the ballistics. A cartridge that can't be excluded. Other guns can't be excluded as having contributed to it. But we don't even know that a gun was involved in this crime anyway. Like that's the state bootstrapping this cartridge into being compelling evidence, is first telling it, the cartridge proves our theory, and our theory proves that the cartridge, is relevant. The cartridge proves our theory that, somebody abducted the girls, a single person abducted the girls, because they would need to use something like a gun to control them. And then the presence of the bullet at the scene, confirms that. It's just, that's what they would be going to trial on if they had not put him in prison and tortured him. V. Grave, this case, along with other instances of tyranny in this country, has me thinking about studying constitutional law. Any resources, organizations, or even lawyers who would be good starting points? There are some great constitutional law resources online. Stanford has a great constitutional law project. I believe Cornell has a good constitutional law project. The one I'm thinking of, I think, is the one at Stanford. It's like an old school website, format. It looks like an old 90s website or something. It's not like real pretty to read, but it's very well organized. They have it very topically organized, and just a lot of good information, overview of the case law, discussion of essentially the same kinds of things that you talk about in a law school class. It's just in a more, you're not reading each and every case. You're just kind of getting a better understanding of what the topics are. So like, you don't actually have to read the lemon case to get the lemon test. They'll just tell you what the lemon test is, which is relating to the First Amendment clause on the, government shall not basically establish a religion, the Establishment Clause. Hillsdale Constitution 101 is a free course. I'm seeing that is potentially a good one. So yeah, those are some options that are out there. Boy, what else is there? There's a lot of orgs that obviously focus on specific aspects of the Constitution. A lot of First Amendment focused organizations, a lot of Second Amendment focused organizations. That tends to not be what people mean when they think about constitutional law. But it is. It's an important part of the whole picture, and it's kind of one of the reasons I've had a little bit of an issue with the ACLU for a long time. And there's a lot of reasons now in today's world, but they're supposed to be the civil rights organization. They protect the Bill of Rights, but they always made an exception for the second, and I never appreciated that. They're all there, be consistent. Obviously, the ACLU is a constitutional organization. So, I mean, yeah, there's quite a few. There's quite a few. Lots of folks that focus on the Eighth Amendment, particularly in the defense context. The Marshall Project is one that focuses on a lot of issues with sentencing, criminal justice, stuff like that. Things that relate to both due process and the Eighth Amendment. One thing I will tell you is that when you go to law school, they often will distinguish between constitutional law and criminal procedure. And you don't always necessarily get, you kind of sometimes need both to get the full picture of the panoply of the Bill of Rights. Because so much of the Bill of Rights, those middle amendments, the fourth, fifth, and sixth, are all they're really dealing with criminal prosecutions and criminal cases. So like search and seizure is a big one, but you might focus on that in law school in more of a criminal procedure class, not so much in con law. So that is something to bear in mind too, if you're looking for research and doing searches and things like that for what you look for. Some of them, who talks about the Third Amendment, who talks about the Ninth. The 10th is largely dead, but there's some kind of scholarship out there, about that. The 10th has at least an interesting history that's worth being familiar with. But those are just some of the things I can think of off the top of my head. So hopefully that gives you a starting point for some of that. Courtney C., I am so disgusted and outraged by what is going on here. I have an overwhelming desire to do something, but I'm unsure of what. Initial thoughts are coming to protest outside the courthouse. Maybe we can get more eyes on it. Thoughts, anything else we can do? The things that I have been advocating for people to do is to use the power that you have to advocate for change. And so there are ways to do that. There are organizations that you can support, ones that work on behalf of wrongfully accused people, like the Innocence Project. There's the Indiana Innocence Project is a new organization. It's still kind of a startup. They could certainly use assistance, I'm sure. Organizations that focus on prison conditions. One that I identified that got referred to me is called Indiana Cure. So they are paying attention to things like these, these DOC institutions and the way that they're treating the inmates in there. So you can donate to them, you can volunteer with them, help out on those types of things if that's the kind of thing that you're interested in. Get politically involved, pressure your legislature. You need to get on top of this. You need to be like auditing this stuff. You need to be doing like investigative hearings on the Idaho Department of Corrections for how this was allowed to happen to Richard Allen. You need to be doing investigative hearings on the Indiana State Police and why they can't seem to manage a cell phone, in a way that can preserve and produce valuable evidence for a trial. We need to talk about why they would tolerate somebody like Lieutenant Holman with how he treated Mr. Allen, how he's been deceptive throughout this case. The Reed technique, you should pass a law banning the Reed technique because it's just some bullshit. You can lean on the legislature to take action over things like that and use the power of your vote. It's a great day to be advocating for using the power of your vote. Same way that you use the power of your vote and your pressure with the legislature, use it with your other elected officials, your prosecuting attorney and your judge. They're ultimately accountable to the public. It's up to the public if they get to keep their position. So if we don't like their performance, we can vote them out. Those are the main ways that I'm advocating for people to get involved, because they are things that have the potential to have a material change. I'm not against protesting, obviously, but protesting is kind of about raising awareness. And yeah, there can always be more awareness, but there is already a lot of awareness on this. That's the problem. There's all this awareness and not really any idea about what to do next. What do we do now? And the answer is we got to act. We got to do something. So those are the avenues that I've been pointing to and places to get started to be able to do something concrete. Take a step, even if it's small. Enough of us do it, then we might have a hope that this won't happen again. Megan L. Any Hoosiers vote for AG based partially on this case and Ole Siegel? How much impact does the AG have on a case like this? The AG is not going to be directly involved in a case like this. This is going to be the county prosecutor who has the decision-making authority over the prosecution. But what the AG does have authority over, the AG is typically the representative for the state agencies. And so whether they are doing that in the capacity of, okay, an agency gets sued and now we're defending you from a lawsuit, or in a capacity of we're advising you about rights and responsibilities and things like that under the law, they have those responsibilities to those same organizations like the ISP and the IDOC. So yeah, you can ask them, how did you allow on your watch Idaho Department of Corrections to open themselves up to this kind of liability with how they treated an inmate, a pretrial detainee, and treated him worse than prisoners of war? And I say that sincerely. I don't mean like historically every prisoner of war ever. That's not what I'm talking about. Currently, yeah. Barred by the Geneva Convention. You can't use solitary confinement against prisoners of war, but you can use that against Richard Allen? Yeah, that's nuts. That should not be tolerated. And so, yeah, the Attorney General who gives the legal advice to the Department of Corrections maybe should be asked to answer that. And whoever wants to assume the office of Attorney General in Indiana maybe should be asked to answer that. What are you going to do about it? Because your policies clearly didn't work. They just ignore them. So what are you going to do to make sure that they're enforced so that we, the taxpayer, don't end up with, on top of the $4 million bill the trial is, however many $1 million bill the civil judgment could be. It's all falling on the taxpayer. These guys aren't suffering any consequences for it. So those are the kinds of questions I think it's worth asking the AG. Jennifer Hoff, you are amazing. Why couldn't RA's lawyers ask one of the detectives on the stand, did anyone else confess to this crime? Is there a rule against it? Well, there's a court order against it. There's a motion in limine that says they can't raise any third-party suspects. So they can't bring up anything to the jury that suggests there's evidence that somebody else committed the crime, such as a confession. They can't bring any of that up. They will be in contempt of court if they do. So that's why. And that's why this is, from my perspective, such a huge problem from an appeal standpoint, that even if they do get a conviction, I don't know how they keep it to stand. I don't know how they defend it. Yeah, a confession is about as obvious a connection, a direct connection to the crime, as you're going to get. It's clearly what they're using with Richard Allen. It's the most direct evidence they have, and it's the reason why, so many people are still to this day convinced, well, he said he did it, so he's guilty. Mendy, line sitting update. Tonight it is a bit damp with 15-mile-an-hour winds and a light drizzle. Thankfully, the wind is from the southwest, so it is an unseasonably warm 65 degrees. I'm glad it is not freezing cold. Oh man, Mindy is a real trooper. She's been out there keeping things organized, keeping things on track. Really grateful. Mindy, if anybody needs an umbrella, please let me know. I will drive out there. I will bring umbrellas. But it is definitely better that it is not freezing cold. Mendy, our lunch line sitters saved the day. Then confusion abounded as we had to move the line onto city property so that ballots could be counted in at the courthouse. Now we are settled in for the night. Very glad to hear that the chaos has settled, has fizzled out a little bit. It's just not good for the county, the sheriffs, the folks, the people in charge, to not be involved at all. It's just been inviting conflict, the way that they've handled this whole issue with the attendance and constantly changing the rules. Things are different all the time. It's not like this is the first high-profile trial with limited seating that's ever occurred. There's lots of places they could have talked to about what's a good way to do this, what's the best way, what will minimize any type of problems and disruption to the court and demand on the court staff and court security. So it does just continue to lead me to think that, there is a reason for the chaos. It's because they want it that way. Lisbeth Stark, thank you for your amazing notes, Andrea. Question, if the phone data is the last offered by the defense, what else would you have wanted given Gull has denied motions for third parties, etc.? In the absence of the third party, what I would really like, I would like to see the van issue tied up a little bit better because, we've seen, I've seen several, screenshots and compilations and things like that of times when a white van or a van has been mentioned in various social media contexts. So I would like to be able to have that established as a fact for the jury that they can rely on. This was out there. Therefore, it's something Dr. Walla could have fed to him. It's not critically necessary, I don't think, but it just would help. It would help. Because the problem is just the suggestiveness that if the jury is going to believe that Brad Weber really was in his van there at that time, and nobody knew that except him, then what would it's a real coincidence that it's there in that confession. So their options are to really nail down that it wasn't there. And I'm not sure that they have. I mean, they've certainly called Brad Weber's credibility into question. We don't really know where he was or what he was doing. It's hard to believe what he says. But jurors can believe him if they want to, you know. So I would like to see that tied up a little bit better. I think it's not a bad idea if we're opening the door now to the possibility of human contact with the phone that's later found under Abby and Libby at 5 p.m. 5:44, 5:45 p.m. and 10:33 or whatever it was, 10:32. It'd be nice to have some kind of confirmation about where Richard Allen was at those times. Get him a firm alibi for those times if it exists. I mean, I would assume he was home, but I don't know, and I don't know if there's witnesses to it. Anything else? I really don't feel like there's much of the state's case that they hadn't already picked apart pretty well before they even got to their case in chief. It's one of these cases where it just fell apart so badly that you can honestly kind of question whether you even need to put a defense case on at all. Could you just rest and go on burden of proof? Sometimes that is a smart thing to do. One thing about being in a trial is that the more you do, the more can go wrong. Things can go sideways. You ask one too many questions. You call the one witness who's had a change of mind, change of heart. You just don't know. There's a lot of stuff that's out of your control. So I feel like they have addressed most of the state's points really about as best as they can. Those are really the two things that I can think of. Mendy, I see some confusion about the line sitting. We are sitting just like we do every night. We just moved 40 feet over to the city sidewalk to give the election workers some room. It's all above board. Yeah, I was explaining how we were told, not going to be able to line up at the ramp until 7 a.m. because of the election. And so then there was chaos about what's going to happen because people are we know people are going to line up anyway. And so what's this going to look like? How's this going to happen? It was just a bad sort of scene without any kind of guidance or oversight. And we had to figure it out for ourselves, which is typical. And I'm glad that it sounds like that did ultimately get worked out between everybody there. Elizabeth Stark, if you can see the crime scene from BW parents and LE visited him at 5 p.m. on February 13th, how come no one saw the girls then? At Brad Weber's parents and the law enforcement visited him. It was just getting dark. And where his house is tucked back from where the bridge is and the trail to the bridge. So the creek, it curves in this area. And as I can see, his house is further back behind this curve. So I don't know that you would necessarily have a great line of sight. I don't know. But it was earlier before it was dark. And so it wasn't a situation where you had to be out there with a flashlight. I think that was one thing, the defense seemed to be trying to do with their testimony is the location of the flashlights. Oh gosh. The other thing I would like to see the trail cam. I would still like to see the trail cam with the people moving across. I'd like to see that. If I don't see it, I wonder why I don't see it. And it makes me think it's a nothing burger. So I'd like to see it to be able to evaluate that. Anyway, yeah, they were looking for flashlights to kind of look at where the search had gone to make that argument that, if they were in the area and nobody found the bodies, then, the bodies must not have been there. But they never did manage to put searchers or flashlights in that area. I mean, really, the closest they got was this trail cam. Freckle Joy, thank you. Well, thank you, Freckle Joy. Really appreciate your support. Ashley, is it possible we could see jury nullification, or is that a thing that only happens if they believe the defendant is guilty? Yeah, I mean, if they think he's not guilty, they'll just straight up acquit him. Nullification would be you think he's guilty, but you acquit him anyway, like because of how the state treated him or because of how badly they botched the investigation. But it's just, thinking he's guilty is not the same as we believe beyond a reasonable doubt. The state has met its burden. We firmly believe, we're convinced that he did it, but we're going to let him off anyway. That's a real tough call on a murder, especially murder of two young girls. Nullification might be an option sometimes when it's more of like a, the guy deserved it kind of situation. You hear circumstances that lead you to think, the guy needed killing. Outside of that situation, I'd be really, really surprised to see it happen because they could be really infuriated about the DOC conduct. But if they are convinced beyond a reasonable doubt he's guilty of the murder, you don't punish the kids and their families for that. The crypto tax lawyer wrote a little X article and tagged you in it. Hope you don't mind. Regal and jurors being able to vote. Thanks for all you're doing, AB. Thank you for that. I will look forward to checking that out. I am never upset about getting tagged on X. I just may not always find it. Sometimes the notifications fly. Sometimes they're slow. So I do my best to keep up on them, but it just isn't always possible, especially these days. Kate E., how would you answer Brett's question in the prosecutor's podcast that if the state ginned up the whole case, why wouldn't they have planted Rick's DNA? I have answers, but curious to hear yours. Well, I'm just not sure that it's really that simple as being able to be able to plant Rick's DNA. They would have to do that in the lab, right? Because all of the collection occurred long before Rick Allen was on the radar or even known to be a potential person out in the area. In fact, I think most of the lab testing happened before too. So just from a timeline perspective, it doesn't work. It doesn't work. How are you going to get like mystery DNA show up in some incriminating way in a new piece of evidence that doesn't get on the radar until after you have access to Rick Allen and his DNA in late 2022? I just don't think there's a viable way to do that. I mean, that's the main issue. I'm interested in yours for sure. That's my reaction because they already did the testing. There's nowhere else to put it. Kaz, if phone was wet, there is a tiny mark sticker size of a small dot inside every phone. So if phone is being wet or moist, it's changing color to red. Oh, that's very interesting. I didn't know that. So it would be a very easy check. If that's the case, very easy check. All they got to do is go open the phone and look at it. Would like to hear that come out. That would be interesting. Danielle Cole, thank you so much for that, Danielle. Joan Four Wheels Backsec, thank you so much for that. Brandon McRoby, a law enforcement officer was definitely involved in the commission of this crime. That is the only explanation for the intentionally poor investigation, the framing of Richard Allen, lots of odiness in law enforcement and corrections. It does seem like one of the most plausible explanations for how all of these things fit. Makes a lot more sense than the single guy perpetrator out of nowhere with no history of anything like this, decides to do it in the middle of the day in this kind of weird fashion. That whole story really doesn't make a lot of sense. The crime scene itself doesn't make a lot of sense. The Odinism does a lot for explaining the crime scene. I don't think they've provided a superior explanation. Covering the bodies, no. The sticks didn't cover them, and there's all those leaves there that you would cover them with if your goal was to cover them. Stadeka, regarding Goal's rulings, at what point does her hypocrisy become reversible error? Have you by chance looked up Goal's record on appeal? So I have not been able to do like the comprehensive research. That is one of those things that is kind of on my radar for when we're in verdict watch, that I can sit down and run that, look at what cases she's been involved with. She's got a long history on the bench. So it may take some time to go through. It's just the longer you're on the bench, the more decisions you've made that have had the opportunity to go up and get reviewed. So I don't know. And I would like to look into that. But I just, haven't had quite the free time that I might otherwise like to have to be able to pursue things like that. But so do keep an eye on my Substack for things like that, because I am planning to follow up on that as soon as we are not spending, so many hours a day caught up in the courtroom and everything. Joy Mortar, a steel 65 Comet trunk could block a cell signal. Oh, that's an interesting idea. That's an interesting idea. Yeah, we don't know when it left, do we? It might not fit the timeline. Because I think it was later in the day when gotta find the names of everybody. It was the exterminator, and I can't remember his name, and I haven't quite finished my little day-to-day update thing of who the witnesses are. Let me see. Did the exterminator fit or not? It wasn't day 17, because that was when we watched videos. Was it 16? Brad Heath was the exterminator. The afternoon he saw it. Oh, it might fit the timeline. It's earlier than I was thinking it was. Now, he saw the similar car at 2:06 ish. It was after he left in the afternoon. That was his last scan. So maybe. I mean, it fits Betsy Blair's. Those are the only two people we have seeing that car. They didn't see it in the same place, but they describe a very similar car. Not a terrible idea. I wonder if being inside a big white Ford Econoline van could block the cell signal. I don't know. I have a big, not white, Ford Econoline van. I don't think it blocks the signal. Starlight Selenite, an epilogue is a great idea, Andrea. Well, we're going to all have a little bit of, withdrawal. You always do. I mean, with a case, you put so much time into it, energy and stuff like that. And if you're new to my channel, there's a lot of people that are new here. You may not be familiar with my pattern because I talk about things that I care about and that interest me. I'm not somebody who just goes out and looks for like what's being played on court TV today just so that I can have an excuse to live stream. That's just not how I roll. So I get involved in something, I go very, very deep into it, and then I check out for a little bit until I find something new that I follow up on. So I have some ongoing, continuing things that I'm interested in, primarily the Brian Kohberger case. I'm starting to get interested in this, the Sheriff Steins, the shooting over there in Kentucky, the judge that got shot. And there's like a few other things here and there that I follow, but nothing like real big on the horizon, I don't think, until we get to Karen Reed having her retrial, and that's not going to be till April. So I've been thinking about, things that I can do in the interim that are still interesting to me, and kind of ease us through we've all had these streams together like every night for so long, and it's going to be over soon. Just tell you how it is. We'll stop doing this at some point, and then I'll stream again when there's a reason to. So I like that idea. I think it would be some interesting stuff to look into. Hedgie Mom, regards to Delphi and Flora Fire. Look into Travis Lee Evans. I will write that down. Flora and Delphi, Travis Lee Evans. I will take a look. Allie Murphy, 28, in Monticello, just north of Delphi, an ISP and her daughter died in a fire too. The husband was a judge who left early for a ski trip in February 2022. Ooh, boy. I've been hearing like house fires. There's just, a lot of people tell me a lot of deaths surrounding this case and kind of in this area. And it really does seem that way. A lot of people getting bullets in their heads. For a really small community, it seems like a lot. I mean, the last community that I was in that was, equivalent to Delphi, a town that size, Dayton, Washington, I worked there. And I think they hadn't had a murder in like 3 or 5 years or something like that. I mean, not a lot. Doesn't happen very often. So something that is a little bit disturbing about some of these connections. Robin, something occurred to me. If the jury find R.A. not guilty, will or could Joel Gohl reject their verdict? No, she cannot. She cannot. The jury has the ultimate power of deciding the facts, and if they decide he did not commit the crime, she is helpless. There's nothing she can do. He can't be retried. Nope. Nadia Tova with a super sticker. Thank you so much for that. Felicia, Weber said he drove van only if he was pulling a trailer. Otherwise, always Subaru. Was it proven he even drove van on the 13th? Proven? No, he just says so. He just says so. Says he drove the van because he dropped off a trailer that morning. But we don't know. There's no verification of that besides he says so. J.M. Sparger, the RR ties on the bridge are a known length. Has anyone used that to measure bridge man's height? I have seen some informal, like some folks who have worked on that online that have, done some various things. I saw one that seemed pretty good. It just, takes that distance and uses it to kind of create a triangle that can show, the relationship between the different points, the height and the width of the tie. But I don't think the measurements at that point were known. So it was kind of jumping around a little bit. The last I saw, it was at about 5'7" or 5'8" was Bridge Guy's height. It's informal. So, you can take that for as much value as you think it has. That is something, it would be nice to see the defense do that, but they're not going to get funding to do that. And I doubt they have, the kind of war chest that they would need to do that type of analysis. Same thing with like a lot of people still have questions about the videos and the picture of Abby on the bridge and like authenticity of all this stuff. It'd be nice to have an expert to be able to look at those kinds of things, look at the metadata and let us know. Has there been any funny business with any of this? But it costs money to do that. So just one more thing where their hands are kind of tied behind their backs. Alyssa Ramirez with a thumbs up. Thank you, Alyssa. Thumbs up to you too. Paula Semek, for us non-Americans, would you go through the amendments very quickly, please? No worries if too unrelated. Oh boy, put me on the spot. First Amendment, freedom of speech, freedom of religion, freedom of the press. Congress shall not establish a religion. Boy, if I forget part of the first, people are going to hate me. I'm pretty sure that's about it. Second Amendment, the right to keep and bear arms. Third Amendment, is the Third Amendment the quartering soldiers? I think it's no quartering soldiers. It's like one, you never hear about the Third Amendment, and I think that's why, because it's not an issue anymore. Fourth Amendment is freedom from unreasonable search and seizure. Fifth Amendment is, there's a lot in the Fifth Amendment. It's general due process. Sixth Amendment is criminal rights relating to a criminal trial. So the right to an attorney is in the Sixth Amendment, right to confront witnesses. There's confrontation in the Fifth. Boy, I get confused sometimes. Yeah, Fifth and Sixth have a lot of overlap, and sometimes I forget which one is which. The confrontation clause is in the Fifth. It's not in the Sixth. Seventh, eighth, and ninth. Sixth, seventh, eighth, and ninth. No, seventh, eighth, and ninth. Seventh, eighth, and ninth really don't come up. The ninth is like a residual clause, but it's not quite the same as the residual clause. That's the 10th Amendment, which is all powers not expressly delegated to Congress are reserved to the states. It's a clause that used to have a lot of power in the up to the later part of the 20th century, but recently it has not. It's basically, it doesn't mean anything. It's just like an extra thing that Congress said, apparently, that the states ratified in the 10th Amendment. So it used to be like a states, kind of a states' rights type of provision, but not really have any power anymore. So that's the best I can do off the top of my head. I am a little embarrassed. I don't at least remember, 7th, 8th, and 9th. I remember generally it's like the 8th is, or the 9th. Oh, the 8th is cruel and unusual punishment. Of course, I remember that. So 7th and 9th, I just don't remember. And then, of course, there's lots of amendments beyond that. I mean, that's the basic Bill of Rights. There have been lots and lots and lots of amendments beyond that I definitely do not know off the top of my head. So, LB, Andrea, if you haven't seen the report on Netflix featuring Adam Driver breaking down our own government's pretrial detainee practices, I have not seen it. I'll write that down. I might be able to log into my Netflix from here. There's like a lot of stuff I'm interested in on Netflix right now. So thank you for that recommendation. 6 Kids UK, local and state police held this too close, too curious, lots of careers on the line, lots of ego. Yeah. Still no explanation for kicking out the FBI. It's just peculiar. Pantoufel, excellent book by doctor I worked with, Waiting for an Echo, The Madness of American Incarceration. You guys have so many good recommendations. I'm going to run out of room for my notes here. Waiting for an Echo by Christine Montross. I will definitely check that out. As you know, I do like me some nonfiction, so it sounds right up my alley. Resist Impulse, repaired my iPhone 6S till iPhone 12 mini came out. 6S had issues with charge port and headphone port, 100% finicky, replaced both. Google search for expert opinion on iPhone forensics, sus. Yeah, definitely sus. And I mean, all of the headphone jacks always run into issues because you run into problems with like it gets loose or the connection doesn't work. People are always troubleshooting that. So there's going to be tons of troubleshooting stuff about headphone jacks, on the forums. It's just that the forums don't relate to cell forensics. They're completely different universes. So that is interesting, though. Lots of problems with both of those. Kaz, did they even done a polygraph on Rick? They didn't, as far as I know. And part of the reason why is because polygraphs are not admissible evidence in court. They will sometimes use them as an investigative tool, like they did with Elvis Fields' sister, I think it was. And she passed it. which, does your investigative tool mean anything to you or does it not? Apparently it does not. So that's the main reason why I would expect it has to be voluntary. He can't be compelled to do it because it's not evidence. So he doesn't really have an incentive to do one, I don't think. The squid. I've noticed that most people that believe the confections is because they don't believe that solitary confinement puts a person under duress and causes mental breaks. That could be. I just think that people have a hard time putting themselves in that type of situation. We always kind of try to imagine how we would be in difficult situations and in hardship and stuff like that. And so we have this self-image and this narrative about who we are that is largely imaginary. I mean, it's not that there's no grounding in reality. We probably know ourselves somewhat well. But it's just one of those things that I tend to think until you're in that situation, you just really don't know. It's important to have humility about that. You just don't know how you would react in an extreme situation until you've been in it. So I think people have a hard time putting themselves in that situation because they think to themselves, I would stay strong. There's just no way. And it is such a unique and extreme set of circumstances that he was exposed to that just is not something people have a lot of experience with. Unless people know somebody who has spent time in solitary, you probably don't know much about it or about what it's like. But people who have been in solitary, they'll tell you a lot about what it's like. I mean, it will break people in days. Melissa Mathis, if Richard Allen is exonerated, can the defense use their evidence to help a new case for Libby and Abby? Does something prevent that? They seem to have answers and girls need justice. There's nothing that prevents it. It's just that it's in law enforcement's hands. And I mean, if Richard Allen had been able to solve the murders, we would have heard it, I mean, I guess you might say no, because the third party culprit stuff has been excluded, and that's viable. That's a fair argument. It's just that they don't have the resources or the tools to fill in the gaps that they would need to do to complete an investigation like that. They can't go get search warrants. They can't get subpoenas. Once a case is over, they're done. So it's on police to follow up with things like that. If you got, I don't know, geofence data that can place certain devices in certain places, that's a place to follow up. But it's just they've shown repeatedly they aren't interested in doing that. So there's nothing about him being exonerated that I would expect to change that. Six Kids UK, the Indiana AG position was voted upon on the 5th of November. That is today. I did hear that was a contested election. So, Jeremy Steffen, was there pretrial motions to exclude confessions based on 8th Amendment violations? Seems like fruit of the poisonous tree. Is there a process to appeal pretrial motion decisions? So yes, they can appeal pretrial motions. They just have to wait until the case is entirely done and over with. You don't get to appeal things like piece by piece in a criminal case, or really in any case, as the decisions are made, because it would just make the case end up taking too long. There's too many decisions made over the course of a case. So they wait until the case is over, and only if you're convicted, because if you're acquitted, there's nothing for you to appeal. You got the correct outcome. You're not an aggrieved party, and the state can't appeal an acquittal. So it's only if you get convicted at the end of trial, then you can go forward. And as part of your appeal, you can then also argue that these rulings on pretrial motions were incorrect. The pretrial motion to exclude was based on the 5th Amendment. The 5th and the 14th Amendment contain the due process clauses. And so, which I didn't mention before, by the way, when I was going through the Constitution. Those are the due process clauses. And so what they had argued is that the conditions made the confessions coerced. They were coercive conditions. These weren't voluntary statements that he made, of his own free will. So There's different factors that they look into to make that decision. Some of the reasons why Judge Gohl said no, there's nothing coercive here is because, well, it was inmates. He volunteered the statements was one thing. She didn't seem to be receptive at all to the idea that the circumstances themselves would have a coercive effect on him. The fact that the inmates, talk to him or whatever, as she claimed, create a part of the bad environment. They're not state actors, so you can't attribute problems with the state investigation to people who aren't part of the state. Those are the main things that I remember. But yeah, it's not technically an Eighth Amendment argument. It's a Fifth and 14th Amendment argument that it's a violation of somebody's due process to coerce a confession from them and then use that to prove their guilt. And so, yeah, they did raise that, and that was denied. 1,000 Julys. Is the Bob Motta referenced earlier the same Bob Motta that was on John Wayne Gacy defense team? It was his father. His father was on John Wayne Gacy's defense team. His father has passed away. John Wayne Gacy has passed away. And because of that, some of the investigative materials from the John Wayne Gacy case, Bob has them, and he has done some podcasts about what is in those. Annalise NZ, I hope this jury achieves a unanimous not guilty verdict. I wasn't going to watch. This is such a devastating case. Abby and Libby won't get justice like thousands of other victims like them. Shame on this LFP and judge. Yeah. I hope so too. It's like it's reached the point where this is like the small little bit of justice that we can get out of this whole situation that never should have happened. It never should have happened. He should never have been charged. Seeing what we see now, and what the original basis was, and how weak and how dishonest. I mean, it was fabricated. They made up parts of his statement. Tweaked his words. Really never should have brought it, but that's going to be, unfortunately, the only little piece of justice I think we can get out of this, if it happens, is, well, at least we didn't wrongfully convict somebody for it after torturing him. Lisa Shelton, yes, I wish you would cover a Sheriff Steins. There's not much out that I can find. I will definitely help you if you come to that trial. That would be awesome. I would like to go to that part of the world. I'm interested in Kentucky. I've never been. I've been to nearby in West Virginia, but I haven't been to Kentucky, and that's where I got some in-laws that originate from that part of the world. So I would like to go see it. It's West Virginia is beautiful in that area. It's spectacular. But yeah, there is not much a law out there about it right now. They've kept it very, very close to the vest. The thing that really stood out to me from what we did see, he had his preliminary hearing. It was very quick. There was just testimony. It was like the probable cause hearing. And it was a testimony from the officer who basically was there at the courthouse and arrested him. And the thing that stuck out to me about it, because he was arrested in minutes of shooting the judge, it's on video. They have it. There's no question about who did it. The question is why. And they had him arrested within minutes. And nobody interrogated him. Nobody asked him any questions about it. And that's a strange thing. That's a strange thing. And it makes me wonder if it's because everybody already knew. Did everybody already know what was going on? Is this kind of one of those situations? I don't know. But I'm going to be interested to find out. Buru Berries, did it seem like any of the aux headphones stuff land with the jury as far as you could see? You couldn't really see. I didn't love this part of the presentation from Ms. Auger because there was a lot of lead in with stuff that just didn't seem like, I didn't know why we were hearing it. I didn't know why we were reiterating the Apple Health data if there's no real disagreement with it. And with just like some of those preliminaries, like the point here, the thing that mattered was that information about the headphone jack. And it just took so long to get there. And this testimony is, I'm interested in it. But most people are going to find this extremely boring. And so you just really run the risk that you've lost the jury's attention by the time you get to your point. So I don't know if there is something in there that is like going to get tied together in argument, or maybe there's another witness. I don't know. It doesn't seem likely though. So I didn't love that, because I do think it made it harder for the jury to find, that gold nugget in the sort of pile of gravel that was the testimony from this particular witness, the forensic cell phone testimony. So it was, I think, a little bit hard to see how it landed. Now, obviously, just from the questions that they asked, they heard it, they're thinking about it. And they're thinking about, are there alternative explanations for it? So, I mean, she ruled those out. But then, First Sergeant Cecil tries to reopen that door with a Google search. That didn't seem to land. That didn't seem to land. Your latex spouse pen fund. Thank you so much. I'm so into these Sharpie S gels now. The ones that Lisa gave me are blue. Like that was my only complaint about my gift pen. It's a black pen. It's not, black pens. I just prefer blue ink. So the ones that Lisa gave me are blue. I'm going to probably be trying them out tomorrow, and I can't wait. Andrea, I have been enjoying your tenacity and dedication to bringing in info to the truth. You're so inspiring as a woman, an attorney, and as an American. Love from New Orleans, Jen. Thank you so much, Jen. That's such a kind thing to say, and I really appreciate it. I will, if I get my teeth stuck in something. I'm pretty stubborn about seeing it through. So, yeah, sometimes being stubborn has some upsides. RK, for all those who think solitary wouldn't produce false confessions, have you not heard of the Stanford prison experiment? It's not solitary, but it shows how quickly psyche is affected. Thanks for your coverage, AB. Yeah, the Stanford prison experiment really just speaks to the conditions as a whole here. Like, you can't create really a place like this where they have the type of control that they have and not expect that to be abused. And that's really what the Stanford prison experiment showed. There's been some criticisms of it lately, and that, it might be overblown or overstated. But the reason why it resonates with people is because I think it does sort of ring true that this is a phenomenon that we would expect to happen. And so if you haven't heard of this, it's a situation where they did a role play experiment in a closed environment where certain people were assigned to be prisoners and certain people were assigned to be guards, and they put them in these roles and just kind of waited to see what happened. And like within a very short period of time, the prison guards were like enormously sadistic, and things were spiraling out of control, and they had to end it early. So there is something about that environment, the dehumanization of the people that are involved, and the control and authority that's given to the people in charge that does have the potential, I think, to really contaminate people's morality. It's just part of the risk of the prison environment, especially in somewhere like the MCU, where people are just they're so helpless, and there's not really. They don't have regular visitation coming in. They don't have the access to the phone. They don't have like the kind of regular oversight. They don't go to a job every day. In Gen Pop, there's lots of ways that if you got abused or something, it would get picked up on pretty early. But in MCU, yeah, you can be locked in a hole and forgotten about for a long time. Paula Semek, thanks so much for the amendments explanation. I should have just Googled it like our favorite expert. I only meant very generally to have an idea of what we're talking about. Yeah, so yeah, I couldn't get them all, but I don't know. How did I do? Was that terrible? Did I embarrass myself? Pamela Wolf, thank you so much for being there daily to keep us informed. Excellent note-taking. You have shed a light on this case. I never believed one person could have killed those two girls. You are a champ. Thank you so much. Very nice of you to say. ACSW, was he ever offered a plea deal? It's not public record if he was, and it's not typically. It's something that happens behind the scenes. So unless somebody chooses to mention it or bring it up in a statement or something, like as part of a motion, you probably won't hear about it. You can sometimes hear about it, like if he got convicted and he's going to be sentenced, then you might sometimes hear about it at sentencing because they'd point out, like, if what they're recommending now is worse than, like way different, way disparate from what they offered as a plea offer, you might bring that up in sentencing. It's not like binding or anything because it just gets very complicated, right? There's no trial tax. You can't be penalized for taking your case to trial. At the same time, the law says that the prosecutor doesn't have to offer anybody favorable treatment. So they've just kind of reversed it to where it's not a tax for going to trial. It's just an incentive for pleading. It's just that when, the incentive for pleading is resolving 98% of your cases, then that's kind of the norm now, right? That's just normal. And it makes getting the harsher punishment because you went to trial look like more of a trial tax. So it does come up sometimes at sentencing, but really not a lot. Paula Semek, we had a chat with my boyfriend about zombie apocalypse and what we'd do. I said then and still believe I would give up first. It's just too much. Even hearing about Rick is too much and gets me down. I think I'd be pretty okay in the zombie apocalypse. I'd be pretty okay in that situation. I worry more about the Captain Trips scenario. I get like every illness that goes around. I'm very susceptible to the germs. So Captain Trips comes through, like I'm out in the first round. Like I'm one of those early. I'm one of the early ones that's just like oozing and infecting everybody else. So that one, I don't think I'd do too well. But I think the zombie apocalypse, I could handle that. I wouldn't, you don't love it. Of course you wouldn't love it, but people are stronger and more adaptable than they think they are. A lot of the times people just really find it in themselves to rise to the challenge. That's definitely something I've learned from boxing and just seeing how people have responded to it, how it changes people. You are capable of much, much more than you think you are. AW with a super chat. Thank you so much for that. And LB, if it's a mistrial, do you fear he will be put in general pop? And if he dies there, hands washed? Oh boy. I don't know. I don't know. It seems like that would just be too obvious. It would just be too obvious. He is still under a safekeeping order, and that's got him at Cass County now. So that's potential major liability for Cass County if something like that happened. I don't think it's likely, especially now that there are so many eyes on it. Up to this point, they did a pretty good job of keeping it under trial, but with the, keeping it undercover, but with the trial, people are going to notice, they're going to pay attention. And so then, especially with this kind of stuff that's coming out, it would be way too obvious. It would be way too obvious. I can't see that happening, but I do worry about something. I really do. Some kind of unfortunate mishap. Somehow he's, like the doctor suggested, you can sometimes have, you can have rec time with safe people. Well, but what's your screening process for the safe people? Things like that can happen. I worry about it. And I also just worry about his general morale. If he goes through this trial and the case is this week and he can't get acquitted, is he gonna lose hope? The appeal process could be a couple years. Double the time you've already been sitting incarcerated. You're going to have to double that now to have a chance at having a trial all over again. I would worry a lot about his morale. He's a fragile egg. That's it, guys. Very good evening tonight. I guess I should go check in on the election. They probably have some announcements now. So I will plan to be there in the morning. Really do get the sense that they're wrapping up, that we probably don't have a whole lot of trial still left to go. But we'll see. This whole time I've never really known what they have in their pocket. But I do just have that sense because of that general rule that you close your case with something strong. And that piece of the headphone jack, they've been teasing that the whole time. The whole time. That's the human hands we heard about in opening statement. That's why they've been pinning him down with the phone always being there. That's their theory, because they found this door to open. So we can see, but I suspect we're getting pretty close to wrapping up. So once they're done with the evidence, we'll get into jury instructions, and then we will get into closing arguments. There's probably going to be a big old crowd for that. But then we wait. Then we wait and see if we get justice here. Cookie Harris, thank you for being sanity and motivation all at once. Well, it's my pleasure. It's a nice perspective to have. I do appreciate that. I do try to keep the sane approach, the calm approach. You take it down here. We don't have to be all crazy about stuff. We just take it down. Things are the way they are, and it's very unfortunate sometimes. We all want justice, but sometimes there's just no justice to be had. And that's a hard truth, but it's a very important one to accept for purposes of our own happiness and well-being in life, because you can spend a lot of your energy making yourself unhappy over stuff you can't change. So, but that said, I am still optimistic for our little shred of justice that we might get with an acquittal. And I would love to see that put pressure on these law enforcement officers to get back to work. I've said they won't do it. Prove me wrong. Prove me wrong. I would love nothing more. Get back to work and find justice for Abby and Libby. That's all I want. Have a wonderful night, guys. Thank you so much for joining me. Thank you for all the mods. Thank you for the wonderful line sitters. Thank you for all of your support. This really has been a team effort that's keeping us going, getting us across the line here. Almost 20 days in. My Lord, it's a lot of days we put in. So I look forward to seeing this wrapped up soon. I will check in with you guys tomorrow and let you know where we're at. Talk to you soon, everybody.